Agency, this my lord. There is an order for
Third, you are entitled for one motion in priority. When do you want? This afternoon. Oh my God. All right, that also will grant. Huh? Green bench matter. Postpone it.
ನನಗೆ ಓವರ್ಸೈಟ್ ಹೋಗಿದೆ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಕಮ್
Oversight all right. 2:30. You will argue the matter. You will argue the matter. Oh, very good. Come.
Can permission for tomorrow for such matter for eviction. Not 20 years of lease has been granted. For 4 years, I am
Same thing. What can we? I told.
tomorrow.
Told. Yes, told.
Lord, this is a commercial court matter, my lords, arising out of a money decree.
All right, commercial court.
Correction.
For what?
This week.
For what?
For stay and for amendment. The matter was heard
Told.
any day this week, my lords.
Any day this week.
Please.
Great. Yesterday I moved the memo, my lord. For you notified directed to the lease matter today. Matter is not listed. Solar matter, my lord. There is urgency, my lord.
What is the urgency?
Sir, vacating application we have filed continuously. The other side is taking time. Just consideration of the application for vacating, my lord, it may be considered, my lord. Though it may take time to hear on the main matter, my lord, at least the IF may be considered, my lord.
But what happens if it is not?
My lord, it is pending since 2016, my lord. We are all farmers.
2016 matter.
My lord means initiation of litigation, my lord. They are illegally terminated the power purchase agreement. The London single judge has quashed that termination and restored the power purchase agreement. Even then, they on one or the other ground, they are delaying it, my lord. They are not allowing us
See,
to
the problem is if we allow any such matters, the lawyers are not cooperating. They take half an hour, 1 hour, their sweet time. They don't come to the point. This is the difficulty about it.
Actually, it is covered by judgment, my lord.
You have informed it is covered by judgment to the other side. If it is covered by judgment, we'll do it.
That is the dispute.
All. Third.
Please, my lord. Tomorrow, my lord.
not 550.
ನೋಡಿ ಎಲ್ಲ ತಗೊಂಡು
I-
ಲಿಸ್ಟ್ ಲಿಸ್ಟ್
I-
ಮಾಡ್ಬಿಡೋಣ ಇಸ್ಕೊಳಮ್ಮ ಎಲ್ಲ ಯು ಕಲೆಕ್ಟ್ ಆಲ್ ದಿ ಕೊಡಿಯಪ್ಪ
By this court, by this bench. All.
Lord, contempt proceedings 550 of 2023 about 8 months. It's not listed even till now. Senior citizens are the complainants in this case, my lord.
All right, please take that memo.
That matter, my lord. Section 8 application is
Yes.
taken up tomorrow. Matter is for trial for tomorrow.
Tomorrow. Thank you.
ತೊಗೊಂಬಿಡಿ ಮೆಮೋಸ್ ತಗೊಳ್ಳಿ ಆಮೇಲೆ
ಎಲ್ಲ
you bring it
ತೊಗೊಂಬಿಡಿ.
I will we will decide about it.
Take-
Please take the memos. Please give the memos.
Memo for being
We'll get it listed. We'll try and get it listed. So many memos are there. Yes.
memo for being spoken to, my lord.
Being spoken to. ಅದು ತಗೊಂಬಿಡಿ. Time waste.
Select yesterday.
All right.
Fill up.
All right. Yes.
Of the petition, it's temple lands. Attaching the temples are being farmed into private sites.
New matter, old matter.
You will. And you will taken at least.
Wait for a while. Wait for a while.
ಅದು ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಬರುತ್ತೆ ಡೇಟ್ ಸರ್
Wait for a while, sir. It will come. Thank you. Adjournment, yes, of course.
Not mainly once a meeting.
ಹೇಳಿ. Withdrawing. Yes, ಮೇಲ್ಗಡೆ ಬರೀರಿ withdrawing. Yes.
One contempt petition, my lord, in myself and Patrick. My lord, it was dropped by your lordship on 3rd January 2024. Thereafter, my lord, it was posted for being spoken the number of times, my lord, it is not posted. On 8th, my lord, it was posted to 20th. My lord, since it's being spoken, my lord.
Sir, ಒಂದ್ ಸತಿ ಕೇಳಿ ಆರ್ಡರ್ ಕೊಡೋದಕ್ಕೆ ಕಷ್ಟ ಇದೆ. So now that lawyers must cooperate, argued matters and taken orders, then again being spoken to.
ಅವ್ರು ಮಾಡಿದ್ದಾರೆ being spoken. ತಾವು
ಇವಾಗ ಏನ್ ಬೇಕು ತಮ್ಮ?
ಈಗ my only request is, my lord, on 20th it is posted at the, since it is
What do you want? Come to the point, please.
tomorrow day after, my lord, 2:30.
Take your chance. Take your chance. But
Already 2:30, my lord, being
ಹಂಗೆ ಟೈಮ್ ಕೊಡಕ್ಕಾಗಲ್ಲ ಇಲ್ಲಿ. Take your chance if it comes, if tomorrow or day after. If it
ಬಗ್ಗೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕಾಗಿರೋ ಪ್ರಕಾಶ್
spoken to our movement.
Then you please inform him, at least take his consent. Simply listing the matter, if it doesn't come, what is to be done? Please take his consent and give it to the court officer any day, anytime we'll take it. Telephone him and then take his consent and give the memo to court officer even without mentioning it.
Yes, please.
Yes, please call the. Yes,
Serial number 41, my lord.
serial number 41.
41.
What do you want?
Short accommodation, my lord. I have to file an application. Another application.
Your Girisha. All right. March. Yes.
Great.
Yes, Ramesh.
About 48, my lord. To be taken up on 6th March, my lord.
With pleasure. Right. 6 March. 56 and 57. Yeah, inform the other side.
Yes, ma'am.
Yes, 56, 57 March. After March, April. Whenever you want.
Entry order may be extended.
Yes, whatever entry models are there automatically. Yes.
For the complainant. And short objections which will, if permitted, we will carry out now itself. Lord.
They are not short, there are 12 in number,
There are 12 in
Please
number.
ask the AO to do.
All are corrections, my lord. Will-
but it must be corrected because it will create a mess. 2 weeks to do the needful. Patil JM, same order. Please comply. No, madam, in,
Number 2 and 3, my lord, in this, my lord, 5 office objections are there.
please comply. madam.
One, we have already complied, my lord, I complied.
Madam, we don't do clerical work here.
Lord, I'll
Otherwise,
comply.
go to the registrar judicial, we'll send the file, sit with him and get it clarified.
I'll get it clarified.
You did get it.
My lord, by 2:30, I'll comply, it, my lord. Small office objections. There is an urgency, my lord, in the matter.
What is the other?
900 crores is the recovery, my lord.
Sorry?
Under the Surface Act. My lord, subsequent purchases.
Then go to, clear it, get us, in the sense endorsement from the RJ, then it will come. Free from,
Today itself we will do.
you do whenever you want.
Lord, will,
We will grant you a week's time. If you have done it, it will come. No problem.
by afternoon we'll do it, my lord. Your lordship may kindly have it
No,
tomorrow.
that, no problem. Who's stopping you?
Tomorrow.
Tomorrow, all right. Yeah, if there are no office objections.
Obliged, my lord.
Yes, 4th time. ComApp, same. 2 weeks to do the needful. Somshekara. CD.
3 weeks, my lord. 3 weeks.
Which one? Somshekara.
5.
All right. 4 weeks. 4 weeks to do the, all right, 4 weeks. Spread for 4 weeks, 7, same order, 8, same order, 9, same order, 10, same order, 11, same order, 12, same order. 12 is what?
Serial number 12.
1 minute. 12, what has happened?
Additional complaint.
Yeah, complied? Yes,
Sir,
miss.
I have filed a memo for withdrawal of one case, my lord, number 40.
Party in person.
12.1.
40 of 2020.
You want to withdraw? Yes, 12.1 withdrawn dismissed. What?
Lord, I have also filed a memo for release.
Please hold on, let 12 be over. What about 12, Mr. 12 also you are withdrawing?
12, there are 1, 2, 3, 4, 7, my lord. In 12, there are 7.
So note 12 you want to withdraw.
No, no, no. In 12, there is a case, connected matter, my lord.
That's right. But what is to be done for 12?
Your lordship, I'm for the petitioner.
Complainant.
Your lordship, this petition would become infructuous, your lordship.
12 is complaint, Mr. Not petition.
PIL, my lord. It's a
Sorry.
CCC connected.
You want a repetition, my lord, which is that serial number 12.3.
We are dealing systematically. What about 12? First you deal about 12. What about the item 12?
1.3, they have not filed compliance.
Mr. We are asking about 12. You are again and again you are
Serial
saying
number
12.1,
12
12.3.
Well,
Please argue about 12.
apologies. Ma'am.
Yes.
My lord, 12, I have filed a memo saying that number 4, as directed by this honorable court, number 4 has to be replaced by number 11. Ma'am. It's
Right.
transferred, my lord.
So you want to substitute.
Yes, my lord.
All right. Memo ordered. Party in person permitted to substitute serial number 4 by
By serial number 11, my lord.
what will happen to 11 then?
He is the same officer for both the cases, my lord. Both the,
All right. To
both the
make
respond-
corrections with regard to accused number 4 permitted, office note be deleted, memo ordered. Yes, you do it now. All right. Yes. 12.1 we want
12.1
to,
I want to withdraw.
we want to withdraw.
Withdraw.
Submits that want seeks leave to withdraw, memo ordered, contempt dropped, all interlocutory applications disposed of. 12.2.
Well, at 12.2, they have not responded. A1, A2 has not responded so far, my lord.
Yes. What do you say, madam? 12.2.
Even, my lord, it is served and we are not represented. Accused number 1 and accused number 2. Karnataka Public Land Corporation.
Center for Smart Governance
Yes, of course.
will have to issue a bailable warrant against you. You take a call. We have no problem. We are talking about accused number 1. Don't disturb proceedings. Mr. Budihal, we can understand party in person in disturbing. We are asking about 1. Accused number 1. So, if you,
Anyway, I'll take the responsibility of intimating.
learned GA submits that she shall intimate, she shall inform A1 and seeks some time. Iva ಹೇಳಿ ತಮ್ದೇನು?
They made parties not because they are officials of the Karnataka Protection of Interest of Depositors Act authority.
So it's all right, but you have to file your counters.
People are permission to intimate. I want to inform them.
All right. All right. 4 weeks to file.
Not as far as accused number 2 is concerned, my lord, they have their own panel advocates.
All right. For appearance and to file objections, if any, 4 weeks, office note be deleted. What is that compliance, objection to compliance by advocate for complaint? You have to comply with some your affidavit, Mr. Do compliance also.
Yes, my lord.
All right. For 12.3.
So 12.3, my lord, they have not filed any compliance report
All right.
last 1.5 years, my lord.
All right. 4 weeks to file counter.
Here,
Then
eight, item number
12.4 Madhukar.
A1 of 23 dismissal. Not present.
Yes, IA1 of 23 dismissed as not pressed. IA2 recalling the order. Adamele hange. Madhukar. None appears. Adjourned. Syed Kalimud. Same order. None appears. None appears for the petitioner.
My lord, 12.6.
12.6. Heli.
My lord, here also they have not filed any compliance report, my lord.
It's not compliance. It's a writ petition. They have to file their counter.
They have collected claims 1.5 years back, my lord. They have not done anything. They're not responding.
All right. We'll call upon them to do.
A1 of 22 dismissal. Not present.
No, for retirement. Counter in 4 weeks. Then Aditya, PF, etc. in 4 weeks. Ella connect.
Petition has become infructuous, my lord. My prayer was with regard to
12.7. Your Aditya. All right. Please give me a paper. Please file a memo, Mr.
Please.
Has filed a memo. Petition is rendered infructuous, dismissed. All interlocutory application disposed of. Next.
In this matter, we have filed additional complaints.
Where is Arun? None appears for the complainant. GA submits that additional compliance, additional affidavit of compliance has been filed. Date for the March or April. Then await 14 await service of R1. Then
14, sir. 14, my lord, I have for appellant. I have filed the memo, my lord, they refused to issue the hand summons. I have filed the affidavit also, bank manager office, my lord.
who has refused?
The appellant is the cooperative bank, my lord.
Who has refused?
And the respondent one, my lord. I have filed the effective memo.
All. Memo is not sufficient. If you
Also,
want us,
affidavit is there. Affidavit
you
is
want
also
us
there.
to hold it sufficient, your affidavit is there.
Affidavit, manager affidavit along with his junior colleague, my lord.
All. Let it- Appellant secretary, all right, Santosh Naik, secretary of appellant bank has filed affidavit dated 12/2/2024 stating that R1 has refused to receive, you are permitted to take out hand summons.
Yes, my hand summons also.
Advocate submits that appellant was permitted to take out hand summon. An affidavit filed by Santosh Naik, secretary of the appellant bank is dated such and such is filed, stating that a R1 has refused to receive the summon, service held sufficient. What next?
So interim order, my lord. The interim order, no, my lord. The learned single judge, my lord, while allowing their writ petition, also set aside the execution petition filed by bank, my lord.
What is the contempt?
Contempt, my lord. It is not contempt, writ appeal, my lord. Writ appeal.
Yes.
Yes, my lord.
So what is the, what are you
Learned-
challenging here?
Yes, my lord. Order passed with the learned single judge, my lord. While allowing their writ petition, instead of remand the matter to the KT, my lord, he also set aside the execution proceeding, my lord. There is no prayer in the writ petition. No, my lord, in view of
One is allowed, matter is remanded to KAT.
Yes, KT, my lord. Till today, my
So-
lord,
so
they have
what
not
is the-
approached KT. And we are also approached, my
What
lord,
is your grievance? The matter is now remanded to KAT.
KT, my lord.
Correct? So what is your grievance?
Grievance, my lord, in view of the order passed with the learned single judge, my lord, the execution case is also set aside. There is no prayer, kindly see the, my lord, order.
That's all right. We'll come to that. Now the matter is remanded.
Yes, my lord.
Matter has to be heard.
Till today, my lord, the matter is not taken up. And the appellant, respondent only is
Can
not.
you move the KAT to take up the matter?
No, no, in space of direction, my lord, the first respondent has not approached. In spite of, you are approached the KT, my lord.
Please understand, learned advocate. Now the matter is remanded before one
Yes,
authority.
my lord.
You have an option.
Yes.
Either you can go to that authority, say that, sir, please take up my matter. If they don't take, there are other options available.
They don't
It is
take.
not a writ appeal.
While passing the order in writ petition, my lord, the learned single judge set aside the execution case filed by us. There is no prayer.
Once the matter is remanded, how can execution be
The
pending?
execution filed before the JMF similar, civil judge.
Learned advocate, we can't explain to you.
No, my
the
lord, it is,
position. Please understand, the matter which is remanded concerns the recovery. Is that right?
yes, my lord.
Then how can,
No,
then
my
the
lord.
matter has to be heard by KAT?
Matter has to be heard, my lord, because the appeal is filed more than 8 years later, my lord. There is a inordinate delay of more than 8 years.
See, either we have told you 3 times. If you don't understand law, sorry, we can't help you. If the recovery proceeding is a subject matter which has been remanded by the learned single judge to the KAT for fresh consideration, execution cannot be pressed.
No, this is not a recovery proceeding. They have challenged the order passed by the ARCS. That is judgment and award passed by the ARCS before the
What is
KAT.
the effect of that award?
No, we are for the execution case before the civil judge, my lord. In the meantime, my lord,
Execution of what?
recovery of the amount, my lord.
Exactly.
Yes, my lord.
Execution of recovery of amount.
Please.
The learned single judge has remanded the matter to KAT for fresh consideration. Is that right?
No, it is not press consideration. There is a delay. In order delay of 8 years, more than 8 years. And the application is
Correct.
on merits only. Not by
ನಮಗೆ ಪ್ರೊಸೀಡಿಂಗ್ ಗೊತ್ತಿದೆಯಾ, ಅರ್ಥ ಆಗುತ್ತಾ ಇಲ್ಲ ನೋಡಿ. ಬ್ಯಾಂಕ್ ನವರು ರಿಕವರಿ ಹಾಕಿದ್ದೀರಾ, ಒಂದ್ ಸ್ವಲ್ಪ ಅರ್ಥ, ಫೈನಲ್ ಟೈಮ್ ಹೇಳ್ತಾ ಇದೀವಿ, ಸ್ವಲ್ಪ ಡೋಂಟ್ ಫಾಲೋ ಇಟ್ ಕೇರ್ಫುಲಿ. ಬ್ಯಾಂಕ್ ನಮ್ಗೆ ಅರ್ಥ ಆಗಿರೋ ಪ್ರಕಾರ ಬ್ಯಾಂಕ್ ನವರು ರಿಕವರಿಗೆ ಮೂವ್ ಮಾಡಿದ್ದೀರಾ, ನಿಮ್ಗೊಂದು ಡಿಗ್ರಿ ಸಿಕ್ಕಿದೆ, ನೀವು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದೀರಾ, ARCS ಮುಂದೆ ಏನು ತಗೊಂಡಿದ್ದೀರ ನೀವು ಆರ್ಬಿಟ್ರೇಷನ್. ಸೊ ರಿಕವರಿಗೆ ಒಂದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದೆ, ಮ್ಯಾಟ್ರು ಎಲ್ಲಾ ಕಡೆ ಹೋಗಿ ಹೈಕೋರ್ಟ್ಗೆ ಬಂದಿದೆ. ಆ ರಿಕವರಿ ಪ್ರೊಸೀಡಿಂಗ್ ಇರೋದನ್ನ ಜಡ್ಜ್ ಸಾಹೇಬರು KT ಗೆ ಇನ್ನೊಂದ್ಸತಿ ಹಿಯರ್ ಮಾಡು ಅಂತ ಹೇಳಿದ್ದಾರೆ.
That is one aspect of the matter, my lord.
Correct.
Another, my lord, we are also filed the appeal before the KT. It is also pending and it is posted for the Mangalore camp, my lord. In that case, my lord, yeah, the respondent only here is filed execution case. In that execution case, they are insisting to pay the amount more than 50 lakhs.
Then kindly move the KT, tell them, ask them to stay the matter. We don't know, you must use your legal, sorry. Perfect.
Like, you have the order pass.
Thank you very much.
Yeah.
We can't explain you, sir. We have no obligation to explain the case. We have understood the case. Thank you.
That it is appearance maybe.
What appear? Yeah.
Because no, notice is also ordered, my lord.
Where is the notice order?
Notice as well as hand summons.
ಮುಗಿತಲ್ಲ
ಆಯ್ತಲ್ಲ.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಿದಾರೆ ಅಂದ್ರೆ ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಹೇಳಿಲ್ಲ ಅದಕ್ಕೆ ನಾನು ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
That's all right.
Await notice.
Full stop. Service is complete. Heard Shri Manjunath Rao Bhonsle. In substance, sorry, this appeal is filed by Nero so-and-so Agriculture Cooperative Bank, assailing the order dated 21/11/2022 passed in WP number so-and-so. The sum and substance of argument of learned advocate is that bank had initiated recovery proceedings against first respondent. Full stop. After the award passed by the ARCS, execution proceeding had been initiated by the bank. Upon petitioner's challenge to the order dated 31/3/2022 passed on IA1 in appeal number 84 of 2018 before the KAT, this court by the impugned order has remanded the matter to the KAT for consideration of the appeal on merits. Thus, the matter will have to be reconsidered by the KAT. Full stop. Learned advocate for the appellant submitted that whilst although the remand order has been passed, the Honorable Single Judge has not only remanded the matter but has also set aside the proceedings in the execution case 18 of 2020 on the file of Senior Civil Judge ACJM.
proceedings set aside.
Further proceedings have been set aside and stay on merits. Further proceedings have been set aside. Full stop. We have perused the order. In substance, the Honorable Single Judge has stopped further proceedings in the said execution case. Full stop. Since the matter has been remanded to the KAT for fresh consideration, the execution proceedings cannot be proceeded with. In that view of the matter, the same have been stopped. We find no error in the order passed by the Honorable Single Judge. Appeal fails, dismissed, no cause. Next.
I can hear for the petition. Lord, while ordering notice, Lord, though your lordship directed to deposit 1 lakh, in the order it is not mentioned, your lordship.
Deposit what?
1 lakh cost,
Who has to deposit?
petitioner. Your lordship
It's not
kind
there.
enough not to
Not
include
there,
that.
all right. Why we had asked you to deposit? RP, is it?
RP.
What is the RP about?
We have filed an application in for additional documents, which was not considered at the time of disposing of the I may be permitted to take back the GD.
Take out?
GD,
TD.
take back the GD.
You
You
are
have
permitted,
filed the DD, is it?
Yes.
take back, permitted. Put down.
All right. While ordering notice on the last date of hearing, comma,
2020,
on 2/2/2022,
24.
it was orally expressed that even to issue notice, petitioner will have to pay costs. Full stop. Learned advocate submits that he has deposited a demand draft for rupees 1 lakh, is it?
Yes.
And full stop, and seeks to take the same back or permit it.
Okay.
Yes, next. Since there is
My
no
lordship,
express order imposing was petitioner permitted to take back the demand draft. Yes,
My lordship, it's my respectful submission
Yes,
before
please.
this honorable court.
yes, please.
I have become the victim of 3 frauds in this court, my lordship. I have filed 3 memos, 1 IA, and all those things are pending since a long time. And the order passed by this honorable court is without taking into consideration the caveat filed by me. And that I questioned in the registry, they cut a sorry figure, and consciously aware of the fact that the caveat petition is received and acknowledged by the respondents, they have suppressed the material facts and they have obtained.
That's all right. Why you have, what is the present state? Rectification of office objection raised on IA1 of 24 directed by the complainant. For direction by the complainant. So there is some office objection on IA1 of 24?
1 of 24.
Objection ದೂರ ಮಾಡ್ಬೇಕು.
No, that's right. No, today this,
Oh, my lordship, there is.
just hold on one. There is
I'm
some,
sorry, madam.
there is some procedural aspect. So IA1, what is IA1 objection?
IA 1 of 24.
Achana.
Copies
All
not
right.
served.
Office objection on IA1 of 24 is non-service, not serving a copy on the
Served just now.
respondent, full stop. Shri Tamuk Bandidya, advocates for respondents acknowledge the receipt of the copy of IA21. Office objection stands complied. Office note be deleted. And then non-filing of reply by, when will you file your? 10 days. 10 days. Advocates, new, no? All right. Sri Shetty seeks 10 days time to file reply. All right. For R2.
My lordship.
1 minute. You say that in your, whatever you want to say, please say. All right.
My lordship.
Yes.
I have filed a memo wherein the respondents are consciously aware of having received the caveat petition, and they have suppressed the material fact here and obtained the interim order.
Fair enough. Let them say whatever that they want to say in writing.
Maybe this is the historical incident in this honorable court. Single person's signature, accused number 2 signature, taken thrice on wakalat in this honorable court, rejecting 3
Oh,
times.
You have made,
Third one is also forged.
so
And
if you have written all that in your your petition, let them have an opportunity of writing, replying. Let the reply come, we'll come.
my humble request is that I'm approaching superannuation. This could be released and maybe
When is your date of super?
next year, March 10th.
Next year, March. We are posting it after 15 days only. No problem. Thank you. Yes. Whatever
Interim order,
automatic.
what is by fraudulent? I have my objection for extending the interim order. ma'am.
All. Right.
It's very clear. My caveat is filed on 8th of.
Please reserve all your arguments on the next date of hearing. Thank you. Yes, next.
Yes, ma'am.
Serial number 18.
Non-filing. 17. What have we done in that?
Orders or presence of the DDL or as.
In the-
Correct. We'll post it tomorrow. All right, tomorrow.
Yeah.
On furnishing a service report. Await service.
Sometimes.
All right. Await compliance, await service report.
Where compliments ಆಗಿದೆ. ನವೀದ್ ಅವ್ರೆ.
Mr. Naveed,
Yes, Lord. I'm for the,
the government advocate says that the order has been complied. Is that right?
please, Your Lordship, I want to withdraw the matter. I'll file the memo, Your Lordship. With this
All right,
regard.
Mr. Naveed, government advocate submits that order has been complied. Mr. Naveed does not refute the same and undertakes to file a memo for withdrawal. Permitted, complaint closed. Next,
Much obliged. Your Lord.
thank you.
Complainant. Handsome. Affidavit, counter affidavit.
Have you complied or not complied? No.
Now they have served the copy.
All right. Reply by, on behalf of, ಯಾರಿಗೆ?
192.
One, two na ಯಾರಿಂದ ಹಾಕಿದ್ರ ತಾವು?
On behalf of 1 and 2.
1 and 2. All right. Reply on behalf of 1 and 2 has been filed by state government for safe. ಇದೆಲ್ಲ ಏನು ಎಷ್ಟೊಂದು ಇಟ್ಟಿದ್ರಲ್ಲ acceptance of service ಎಲ್ಲ office note be deleted for safe complainant. March alone date. Ajay, compliance 2 to 4.
My lord, the request for pass over, because in, before the single judge, my lord, we have challenged the SIT order. It is being heard today.
When
Because.
a new advocate has come,
Pardon me.
learned advocate says that Mr. Ramesh has given NOC, he has now come. So what is the point in giving pass over?
My lord, maybe had tomorrow. My lord. Because
Not possible. You come on 20, you come on 30th, sorry, you come on 5th March.
Look.
Learned advocate, ತಾವು ಯಾರಿಗೆ? 3 and 4. What is your good name? What is his name? No. So and so advocate submits that his senior Mr. So and so has been instructed to appear for A3 and 4. Full stop. They have obtained no objection from Mr. N.K. Ramesh. Full stop. File wakalatnama on so certain such date. Yes,
my lord,
Mita.
request for the shorter date, my lord, because 25% of the payment has been started.
25% of?
Payment has been not yet been released, my lord. Till now, only the 75% has been released. And
So what is to be done for that? You see, he is a new advocate. He does not have papers.
no, my lord, because in the SIT matters, it is being heard today, my lord, it will be disposed of today. It may be had in.
If anything urgency is there, then you move, we'll consider. No problem. If anything happens in that court,
Yes, my lord.
if there is still graver urgency, we'll consider. Thank you. Next.
The complainant.
Let us file objections. When? All right, 1 week we'll grant you. No, yes, filing of reply by so and so, A1 to 5, non-filing. You are Mr. Srinivas Reddy. Mr. Srinivas Reddy for A1 to 5 seeks 1 week's time to file objections of granted office note be deleted. Why A6?
6, 7 and 8, my lord, they have abetted and aided the commission. They are not parties.
All right.
My lord,
Sri Nayak learned.
may direct notice to them.
Learned senior advocate Sri Nayak submits that A6 to 8 have abetted
Abetted and aided.
and aided the contempt. Submission accepted. Issue notice.
Yes. And then, my lord, annexure G, we will not rely upon, my lord, your lordship.
Next, he further submits that complainant does not rely upon annexure G.
Annexure G.
Hence, translation is not necessary. Submission accepted. Office note be deleted.
Great.
Yes. Next.
Indigo?
It does matter. Within 2 weeks, not we are going to complain.
All right. Is that all right? If he files an affidavit to that effect, you are happy?
They are not taking firm steps, my lord.
extreme, though, the advocate for
No, please understand. Learned government advocate on instructions is saying that they will undertake to comply it within 2 weeks. Are you happy with that?
Yes.
All. You will file it in writing? Who is the officer
Headquarters assistant
of?
of
Minister of Animal Husbandry.
Animal husbandry. Miss so-and-so or Hesar Barin, headquarter assistant of animal husbandry, we will not accept because the A1 or A2, whoever the concerned officer has to file.
Commissioner.
She must file the affidavit. Submits that the A1 or A2, who will file?
Commissioner of.
A1.
Commissioner of Animal Husbandry shall file an affidavit undertaking to comply with the order within 2 weeks, within
2 months.
2 weeks.
2 weeks.
Full stop. Learned GA on instructions in the part. Learned Sri Ramareddy, learned advocate for the complainant is satisfied. Contempt closed with liberty to reopen if need arises. Yes, next. Watson. Will file compliance. Watson undertakes to file compliance affidavit within 1 week. Please be clear. Please be, we are recording. Can we? Objections, if any, in 1 week. Watson seeks a week's time to file objection. 1 week, yes.
For the complaint.
All this 1 week, please put it in March, April, yes. Chetan,
Partial compliance level.
they are not happy with that.
My lord, they are supposed to.
All right.
Civil court.
All.
So far as remaining portion is concerned, it will be clear.
They'll file an affidavit.
Let them file petition. I'm agreeable.
They are happy. All right. Learned GA submits that order has been complied in part. The remaining portion of the order will be complied within 2 weeks. And an affidavit of which officer? BO, who is his accused number?
He is not made accused.
Who is the concerned person who will be responsible?
So far as land is concerned, NDAO has filed the.
Fair enough. The person must be bound, whoever files the affidavit.
So he is not a party.
BO undertaking to do what?
Undertake to deposit balance of rupees 18 lakhs.
Undertaking to deposit the balance amount of about rupees 80 lakhs.
52,338.
80 lakhs 52,338.
18.
Within how many payment to make the payment within 2 weeks. Full stop, submission accepted. Learned advocate for the complainant is satisfied. Full stop, contempt closed with liberty to reopen if need arises. All interlocutory applications stand disposed of. Sagar.
Complaint. Not gave it respond in the writ appeal, madam. No copy served on me, not on me.
Yes, what is this content?
Relating to the allotment of the schedules on the. They are entered into a lease deed for that.
So who are you? What have you done?
We had issued a notification for complying for establishment of the.
No. What is the violation, Mr.? What has the honorable single judge or this court has passed an order? What you have not done? That's all. Quashing the impugned order so and so issues the respondent to treat petitioner's candidature. Petitioner's candidature as falling in group 1. Have you complied or not complied? You have filed writ appeal.
25.1.
As the order of the honorable single judge has been stayed.
It's still in office of non-compliance of office of.
So what is on merits? Why you can't do?
Petitioner entered into a lease deed. It was issued by section 5 of the Karnataka Land Reforms Act. So as on the date of application, we do not have a valid conversion of the land. So I had entered into a lease and agricultural land, leasing of agricultural land is prohibited by the act. So we had said that.
So he had an agriculture piece of land. So you could not allot the petrol from there. That's your case. Is that right?
Not subsequently, we have taken we have converted it into non-agricultural land. my
No,
lord.
sir, as on the date of filing of the application, did you have a land converted for non-agriculture purpose?
No, my lord.
No. So, all these oil corporations, they will issue some certain guidelines that as on the date of filing of the application, things, otherwise thousands of applications, they will never be able to finalize any application. Do you have any idea how many applications come in petrol pump for this gas, etc., etc.? In thousands.
Subsequently, that has.
So, if this gets embroiled, it will be there's no end to that. Sorry. Please try your next time whenever they notify for the next petrol pump, try for that.
Lords, may kindly pass over, my senior.
No passover in this. That's all is the point. On the date of filing of application, your land was not converted for non-agriculture. Are you the owner of the land?
Lords, I have entered into lease agreement.
Oh. So your vendor himself did not, it was not, sorry, your lessor had not converted the land.
Yes, Lords, that has been converted, my lords. The learned single judge has to consider that aspect and pass the order, my lords.
Subsequently.
Subsequent.
No, not possible.
Lord, may kindly pass over, my lord. Senior or argument.
Notice to
You take better.
My lords, I am caveat respondent, my lord.
You are caveat respondent, sole respondent.
Sold.
You have filed the caveat, all right.
No copy has been served, my lord.
All
The
right.
same is served and.
There is CDF 29 days. We will condone the delay. 29 days. All right. Notice have it is there. Delay condone. The respondent has no objection. Delay notice. Respondent has entered caveat. Heard Sri Subhash Chandra and your Sagar Bibi, is it?
No, no, Sajid Ahmed. I'm junior.
Rupa. Sagar Bibi.
Bibi is my senior.
Correct. What is your name?
Sajid.
Mr. So-and-so for the Wakalatnama filed by the caveator Sagar Bibi is accepted. Sri so-and-so, next line, Sri so-and-so for Sagar Bibi submits that he has no objection for condoning the delay of 29 days. Full stop, IA1 allowed, delay condoned. IA2 add interim order as prayed for till next date of hearing with liberty to file application for modification. All right. Interim order till next date of.
He may be served on him.
Please give. Yes. Yes. Next.
Match, I appear for the appellant in the writ appeal and the respondent in the contempt petition. My lord,
Right.
the single judge's order has been stayed, my lord, so therefore there is no case of contempt. My lord, as far as the issue is concerned, my lord, this is a.
So that is a matter for what? Rectification of his objection on Wakalat filed by respondent, Mr. Rai. That's all. It has been stayed. No? Do you?
No, my lord, subject to the eventual outcome of the writ appeal. So, my lord, the issue is this, my lord.
So we'll do one thing. We'll close the contempt with liberty to reopen if need arises. No, but there is a stay order in writ appeal. How can we do? That's a different matter. Please argue. That's a 23 appeal, sir. Please understand. Matter has been admitted. No? Then no point in simply keeping page full of connected matters. Matter is not admitted. Snare? Whether appeal is admitted.
But a detailed order has been passed, staying the impugned order. And my lord, the question is, my lord, whether the law laid down.
Fair enough. Fair enough. No problem. You reserve that. Then we'll admit the appeal and keep it. Fair enough. But please understand, if the writ appeal has to be allowed or dismissed, both parties have to be heard. Correct. Please take your chance, no problem. We are not stopping you. then CCC will close with liberty to file a memo for reopening. Simply ಅದಕ್ಕೆ correction ಎಲ್ಲ ಮಾಡೋದು ಬೇಡ. ಏನು ಹೇಳಿದ್ರಲ್ಲ ಮಿಸ್ಟರ್ ನಾಯರ್, ultimate decision ಏನ್ ಬರುತ್ತೆ we will comply with that ಅಂತ. So we'll do like that. Then see, one proceeding must go further, otherwise it's not correct. We will do one thing, we'll admit with liberty to file application for early hearing. You rectify the office objection on Vakalat. All right, you do what. Mr. Rayappa seeks 2 weeks time to rectify the Vakalatnama. Full stop granted. Shri Nair for the appellant, learned senior advocate for the appellant submitted that this court has granted an interim order after hearing both.
After hearing.
That is his submission, sir.
Both the matters were tagged.
All right. Has passed an interim order staying the operation of order in writ petition. Full stop. In that way of the matter, connect CCC 1034 of 23 is unnecessary for the time being. It is closed with liberty to reopen if need arises. Office note be deleted.
So the interim order may be extended.
Yes, interim order extended.
Great.
All right. For admission 18 March.
Obliged.
Yes.
27.
For the appellant, as far as translation is concerned, I'm not relying upon any of that.
All right. Learned advocate submits that he does not rely on annexure B, B1, B2, C to F, and G. Hence, translation is not necessary. Counsel submission, advocate submission accepted, office note be deleted. Next.
My Lordship, this is a case, my Lord, where a writ of mandamus, recovery of amount has been ordered. It is not not at all admitted debt, it is a time bar debt. And they have gone up to, the respondents have gone up to the National Consumer Disputes Settlement Commission. I have produced the order at page 158. And the operative portion is 159. They have withdrawn that revision. Their approach, they approach this on court without there being an explanation under section 14 Arbitration Act. Debt is not at all admitted. It's a
1,97,000 rupees to this farmers.
It is not the farmers. He was the former director of the sugar factory. Even that, my Lord, there is no admission. There are even for the consumer forum, the debt has not been quantified. Nowhere the debt is admitted. So.
1 minute.
Paragraph 30, page 32.
Supplied sugar.
This said that it is supply, whereas there are from different accounts. That will pertain to the year 92-93. I have not admitted, I have filed a detailed statement of objection. There is no admission of debt.
1 minute.
And the quantification also not been determined by the district forum earlier. And all these in paragraph page 29, the figures do not tally at all. Except the passbook, there is no effort has been made to prove the debt before the learned single judge. After withdrawing that revision petition, they should have some basis. Admitted that the petition is to supply sugar cane, then they have received the amount and the same amount is deducted for the purpose of issuing shared certificate to the complaint. Though it is contended by the foreign sugar factory that there is an efficacious order available under the cooperative society, the petition being sugar cane. And the are entitled for the amount, and it is nearly 23 years. The petitioners have amount, petitioners are entitled to, and petitioners cannot be directly approved cooperative society for the year. Now, I have produced the order of the district.
All right, interim orders. Kishore,
Here, my lord, there is a direction to reinstate, my lord. They have been deliberately, my lord, delayed. Order.
28,
Is the writ up
33 is
connected?
it? All right, we'll take up with 33.
Very well. Order. In fact, as against the very same order, I too have filed an appeal, my lord, because full back wages have not been granted.
So let all be heard together. Please give the writ appeal number.
Urgency is, my lord, he is reaching superannuation by this month end. Deliberately, they have been delaying. In October, they filed this writ appeal, kept it with the office objection soon. That is why I filed. But some date, my lord, I will give the number, writ appeal number, 146023.
As prayed for by Sri Keshav, but post along with 146023 and item number
Serial number 38.
and 1287 of 2023. Please agree on a date, take it, no problem. By consent,
20th.
20th of March. March,
Next.
no, February not possible. Please.
He is
please bear-
retiring, that is.
Sir, take, if you want 26th, we'll give it. It's not possible. There are so much of pressure.
Yes, sir.
26th. Yes.
Order of the lunch single is complaint. Appeal for the complainant.
A1.
Order is complete.
Computed. You are Mr. Patel.
Mohan Prasad.
Mrs. So-and-so for complainant submits that order has been complied. CCC closed.
For the complainant.
Further survival. Sorry? Ishu Baba.
Here for the complaint.
What is
Not
it?
complied with the order.
Yeah, complied.
But there is no order been passed by the accused, my lord. They have just issued the notice.
Please examine if your friend is saying complied. Learned advocate. ತಮ್ಮ ಹೆಸರೇನು? Shri Manjunath Prasad submits that compliance affidavit has been filed.
Rectification of office objection.
Seeks time to comply with the
Sachin.
office objection on the compliance affidavit. Yes, Marchal on date. You have filed a modification. All correct.
Next week, because the matter pertains to 17B wages, so next week a lot.
Time will. Marshal told. Leonard, what's your Mr. Ajit? No, what's your good name? Mr. Harish submits that for complainant for accused submits that he has filed an accused has filed an application seeking modification of the order complaint. Order passed by whom? By the Honorable Single Judge. Will stop. Call in March or April, whatever, March.
Lord, may I, during the first week of March.
All right, first week. 6th March.
Great.
Samrudh Suraj.
Lordship been complied.
Nagrale A2. Yes.
It's been complied.
Complied.
You should.
Yes. Mr. You are Suraj Hegde.
Samrud.
You are Samrudh. Yes, Mr. Samrudh, the advocate submits that order has been complied. CCC closed. All interlocutory applications, if any, closed. Girish.
Pertains to PG NEET allotment, my lord. Your lordship had passed an order on 19/1/2024, my lord. Few corrections in respect of the dates in para 5, 13 and 18, my lord.
What is the order? Please give. What is the mistake? Tell them the order.
My lord, par-
Ten, 2023, yes,
Please, my lord.
done.
And para 13, my lord.
Consider para 5, para
13, my lord.
13,
Page 10 of the,
yes.
the last but one line, my lord. Her rank is being depicted as 1,70,997, my lord. Last but one line.
1,70,997.
That has to be replaced by 1,37,089, my lord.
Correct, ah? Amale.
And para 18, my lord. Page 13 of the order.
Hmm.
Last but one line, my lord, para 18, 13/10/2023 has to be replaced by 20/10/2023.
2010-2023.
Please.
The advocate for the petitioner submits that there are typographical errors in dates mentioned, typographical errors in para 5, para 13 and 18. Full stop. They shall be. Sri Ramesh has no objection to correct them. They are accordingly corrected as such. Pencil Mattenu?
Also, my lord, one order, its date is not been mentioned in para 2 of the operative portion of the order. I request my abmal submission is to add forthwith, my lord, because 19/1/2024, my lord, they have not complied with the order. And they are taking the contention that there is.
PA shall allot MD radio diagnosis seat in favor of petitioner and issue necessary order. Yeah, Kotiline.
That be.
What review?
And it is.
Going to SLP. Or Madala.
Forthwith ಅಂತ
ಅದ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಕೊಡ್ಬೇಕು ಅದ್ ಬೇಕಾದ್ರೆ ನೀವು CCC ಮಾಡ್ಕೊಳ್ಳಿ. ಎಸ್
ಪ್ಲೀಸ್.
ಥ್ಯಾಂಕ್ ಯು.
Okay.
ಆ ಅಪ್ಲಿಕೇಶನ್ ಅದು ಕೇಳಿದ್ರ ಫೋರ್ತ್ ವಿತ್.
Yes, please.
Sri Ramesh has objection with regard to adding the word forthwith in direction clause. Direction clause 2.
Operative portion of para 2.
In direction clause 2. Full stop. We have heard. We do not deem it appropriate to add the said word. Full stop. Next.
Procedural memo
For withdrawal of the.
Yeah, filed memo. All right, withdrawn, dismissed. Withdrawn, contempt closed or dismissed. Mohammed Shamar. This. 1 minute. PF, he has to pay PF itself.
Already on notice, I'll pay it, my lord, I'll pay it today.
You have paid.
Yes, my lord.
Are you appearing for whom?
Only one accused.
Are you appearing for the? Yaru accused are?
Bangalore East.
What is the matter?
But
Complaint.
it may be taken up. It may be taken
Again.
after, my lord, then I'll see.
No, you see that we'll record his statement. Tasildar is present. Yes, if it comes.
But it may be resolved now.
Huh?
But it may be resolved.
We'll close with liberty. Matten madbeku.
Maybe.
Ashena?
close
After, my lord, if the RTC is generated, I'll be able to see it online today. Day after tomorrow, I'll come make my submissions before this. Day after tomorrow.
All right, yeah. Hig barಕೊಳ್ಳಿ. Government advocate submits that RTC will be generated during the course of the day after tomorrow. Yes, Tasildar present. Their presence dispense for further hearings, on further dates. Next. Sumoto.
report, my lord.
Yes, ಸುಮೋಟೋ ಸಂಪೂರ್ಣ ಬೇರಕ್ಕೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅದ್ರ ಡೈರೆಕ್ಷನ್
was quashed, upheld, then SLP was rejected. So far as award is quashed, matters are pending. Now, my lords, at at 7 o'clock in the morning, there are 10 bulldozers, 300 security.
Please permit us to interject. Today, there is no demolition.
There is an order of protection by your lord, my lord.
Then please take it up in March or April, whichever the date you want, convenient date, and argue. Because we'll not be able to write any order now.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆ
Lot of compliances are there. By consent, follow on certain such. All compliances in the meanwhile. Please do that. No problem. Compliances. No, all compliance, whatever compliances, please do it. Otherwise, every file we have to take and do, we have to do compliance, we will not do it. Compliance in 4 weeks. Yes, next.
Interim order may be extended.
Yes, all interim orders stands extended. Next. Same thing. Same problem. So many compliances are there. Compliance. Correct. So 5 matters have to be heard. Compliance in 4 weeks. Yes, we'll give interim order, whatever is there will be extended. Yes, COMAP 40. What is this?
Application for condonation of delay.
Condonation is all right. What is the matter on merit?
Lord, on merit, I am the successful claimant in the arbitration tribunal. The award is in my favor. In commercial, under section 34, the order on the ground that the arbitrator could not have ordered inspection, only on that one limited ground. That is not even a legitimate ground under section 34.
What is the main list about in the arbitration?
Before the arbitrator, the main list was, I was a successful bidder for restoration projects in Mysore. I provide restoration services for heritage buildings. There was a bid, tender floated, I succeeded in the bid, and I provided the services.
So what was the award?
The award was a payment of my money.
All.
I succeed.
Yes, madam.
They have to show the sufficient cost. So they are the.
No, for 95, this IA, you have objection. Yeah, filed your objection. What is the objection? What is the reason given?
My lord, is that page 81.
What is this, madam? No, you have filed objections. Are you pressing, are you seriously contesting this? You have been coming to this court. We, up till these delays, we are condoning. Unless and until that.
Now, it could be or not, but there is sufficient cost. 75 days.
That is why we are asking you, if you are contesting this application, or you are not, if you are seriously contesting, we'll find out what could be done if a ruling has to be given or otherwise. Otherwise, we'll go on the main appeal. That's how we are leaving it to you. No problem. You have an option of lawyers. You have a prerogative of saying you want to contest. No problem. No, not that. No, not like that. See, this court you have been coming regularly. Normally, small delays by consent we close. If somebody wants a ruling, we'll hear and give a ruling. That you want a ruling on that? All right, March 15th. Next.
Then they short time today.
What is that matter? Modify the order dated when so.
If they compare to the contempt, we have paid them amount, again, the.
Sorry?
For tomorrow.
41.
Compensation put on the case.
So if it is adjourned, it's adjourned. Why?
What they do, whenever they want to do, your worship, at least wanted to dismiss, then they take time. Again, they move and no time to be granted. Because you have.
See, as it is, we would always welcome any adjournment at this point of time. But the point is, if you want us to take, but please see that today we have 60, 70 memos.
Yeah, this is not.
Anyway, it's coming in March 20th.
No. Tomorrow.
No, but please ask the other side, what is the matter? Unless it is very serious or some extraordinary, we can't.
Then what they do, suddenly they come and move the matter. They are asking for under, they are arguing the petition 172.
So we'll ensure that it doesn't come till March end or whatever the date we have given. Don't worry. That instruction we can give. Please ask your EOR to inform the other side. They have to make note. Yes, Amarnath.
It's not a blood. Mr. Amarnath requires some time.
All good. Amarnath wants time, all right? Yes. Amarnath, Mr. Peter seeks time for appellant.
His cousin
Vakil time ಕೇಳಿದ್ರೆ ನಾವೇನ್ ನೋಡೋದು?
There is a.
All right, Peter, we are giving you. When do you want?
Next week, you'll have to.
Not next week. March alone date.
Infractions.
Infractions.
ಆಗ್ಲೇ ಅವ್ರು ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರದ್ದು ಅಪೀಲ್ ಏನು ಅಂದ್ರೆ ವಿತೌಟ್ ಇಶ್ಯೂಯಿಂಗ್ ಅರೆಸ್ಟ್ ನೋಟಿಸ್ ದೇ ಇಶ್ಯೂಡ್ ದಿ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಡೇಟ್ ಹ್ಯಾಸ್ ಆಲ್ರೆಡಿ ಲ್ಯಾಪ್ಸ್ಡ್.
Oh, date has elapsed.
ಅಲ್ಲ because I have no my instructions that there is a bereavement in the family.
ಆಯ್ತು. ಕೊಡಿ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮಾರ್ಚ್ ಅಲ್ಲೇ ಅದು. ಸರ್ ಮಿಸ್ಟರ್ ಬಾಪಟ್ ರೀಚ್ ಆಗಲ್ಲ ಸುಮ್ಮನೆ ನಿಮ್ಗೆ ಅರ್ಲಿಯಸ್ಟ್ ಡೇಟ್ ಕೊಡ್ತೀವಿ 27 ಫೆಬ್ರವರಿ. ವಿಶ್ವನಾಥ್ ಹೇಳಿ.
ಇವರು 13% ಬಸ್ಸಸ್ KSRTC ಹೈರ್ ಮಾಡಿದ್ದಾರೆ ಪಾರ್ಟ್ನರ್ಶಿಪ್.
Admission
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ
application ಹಾಕಿದ್ದಾರೆ.
ಹಿಯರಿಂಗ್ ಮಾಡ್ಬೇಕದು.
Hearing ಮಾಡ್ಬೇಕು.
ಹಿಯರಿಂಗ್ ಆಗ್ಬೇಕು ಮಿಸ್ಟರ್ ನರಸಿಂಹಯ್ಯನವರು. ಹಾಫ್ ಎ ಮಿನಿಟ್ ಅಲ್ಲಿ ಆಗೋ ಕೆಲಸ ಅಲ್ಲ. ತಾವು ಹಾಫ್ ಎ ಮಿನಿಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬೋದು, ನಾವು ಅದನ್ನ ಬರಿಬೇಕು, ಎಲ್ಲ ಮಾಡ್ಬೇಕು.
24 ಇದು 4 ಹೈಕೋರ್ಟ್ ಕಮಿಷನ್ ಮುಖಾಂತರ ಆಗ್ತೀನಿ 8 ಲಕ್ಷ ರೂಪಾಯಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟು ಕಟ್ಬೇಕಾಗಿತ್ತು ಅವ್ರು?
ಆಲ್ರೆಡಿ ನಾನೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ. 10 ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಲಿಕ್ವಿಡೇಷನ್ ಅಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಏನ್ ಹೇಳಿದೆ ಅಂದ್ರೆ 16
ಒಂದ್ ನಿಮಿಷ ಇರಿ. ವಾಟ್ ಇಸ್ ದ ಮ್ಯಾಟರ್ ಅಬೌಟ್ ದಿಸ್?
It is only arbitrator award ಆಗಿತ್ತು.
For
money payment.
What is the list in the arbitration?
The decree was passed, ex parte arbitration decree is passed.
Sir, please state the fact. What is the list ಅಂದ್ರೆ ಅದಕ್ಕೆ ಏನು ವ್ಯಾಜ್ಯ ಏನು ಅಂತ ಒಂದ್ 2 ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕು.
Firm ಇತ್ತು.
ಯಾರ್ದು?
This is the appellant Shivappa, Birlappa, Hulkone and the respondent.
Right.
ಮಧ್ಯದಲ್ಲಿ ಆ
ಒಂದ್ ನಿಮಿಷ ಇದೆ.
The partnership firm came into existence and subsequently there was a dispute and the partnership deed was dissolved. Your Honor.
So what was the prayer in the before the arbitrator?
Arbitrator prayer, he has asked for the payment of the money and accounts. Your Honor.
Right. So what did the arbitrator do?
Arbitrator ಇಲ್ಲಿ ಆರ್ಡರ್ ಇಷ್ಟು ಹೇಳ್ತೇನೆ ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡಿದ್ದೇನೆಂದ್ರೆ 12,500 per month from February 2003 till 28/11/2008 with interest at 9% per annum. That award has been challenged by me. Subsequently, that award
What has happened in the commercial court?
commercial court dismiss ಮಾಡಿದ್ದಾರೆ. ಅದರ ವಿರುದ್ಧ ನಾನು ಇಲ್ಲಿ
Correct.
present appeal. And in the execution was
What is wrong in the order passed by the commercial court?
because here what had happened here partnership deed dissolution ಆಗಿರೋದು
Commercial, see, the scope under 34 itself is less. Scope and more so 37, there is no scope at all practically. So what is the such a mistake that the commercial court has?
Court has not considered the defense taken.
What is then? ಒಂದ್ ನಿಮಿಷ ಇರಿ ದಯವಿಟ್ಟು. Please show us what is the commercial court's order. Where is that?
Commercial court order ಇಲ್ಲಿ 32 ನಲ್ಲಿ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ. Page number in page 32 ಇವರು.
Commercial appeal, page 32.
In page 32.
So it's so.
Page 32. Para 41.
ಸ್ವಲ್ಪ ತಾವು ಸುಮ್ನೆ ಇದ್ರೆ ನಾವು ಹಿಯರಿಂಗ್ ಮಾಡ್ಬೋದು. ನೀವು ಇದೇ ಡಿಸ್ಕಷನ್ ಮಾಡ್ತಾ ಇದ್ರೆ ತಾವು ಯಾವ ತರ ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ.
Page 32 41 paragraph ಅಲ್ಲಿ the plaintiff is contending with the partnership.
ಸ್ವಲ್ಪ ತಾವು ಸೈಲೆಂಟ್ ಆಗಿದ್ದು ಅಂದ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಾಗುತ್ತೆ ಏನ್ ಕೇಸ್ ಅಂತ.
An ex parte award, Your Honor.
Ex parte award.
Ex parte award. The dissolution deed was
Award copy is here.
award copy is there.
Please show.
Copy
Page
44 in the start. Page number 44.
44.
Commencement.
ಅಲ್ಲಿ
One thing, Your Honor. And also here, before the executive court has not produced the original arbitration award which has been given to him. Only copy has been.
No, execution is a different matter. ಅಲ್ವಾ?
ಆಮೇಲೆ our contention is that firm was dissolved, Your Honor. That he has suppressed the same and got the award passed, Your Honor, without disclosing the dissolution of this partnership firm.
How does the commercial court deal with that?
They say that we cannot believe that ಅಂತ ಹೇಳ್ಬಿಟ್ಟು reason.
ತೋರಿಸಿ paragraph.
Paragraph 41, 32 page number, in page number 32, Your Honor. Para 41, Your Honor. The plaintiff is contending the partnership with the claimant
and Shivappa Dulappa Ulkunda was resolved by virtue of dissolution deed dated 17/3/2002 with effect from 5/1/2002, Your Honor. The partnership was enforced for a period of 7 days only. It is not possible to conceive that how parties could.
So as per this
It is not-
award,
Yes.
as per this award, how much money you have to pay?
Now, I have paid the entire up to date
Sir,
20.
when we ask a question, please be kind enough to answer that. How much ಅಂದ್ರೆ quantum? ಎಷ್ಟು ಕೊಡ್ಬೇಕು ತಾವು?
Objections to vacating stay in page 4, award amount is 8,62,500.
We'll dismiss it in limine, mister. If you don't answer questions.
Original amount.
We are asking you a simple thing. According to the award, how much money you have to pay?
4,70,000.
24 lakhs?
23,000.
Say about 25 lakhs of rupees. How much have you deposited?
I have deposited first 8 lakh rupees were deposited before the High Court. That has been permitted to be withdrawn by the respondent. Subsequently, now I have again deposited sum of rupees 18 lakh 70,218.
18 lakhs 70,000. So totally 26 lakhs. 26 lakhs you have deposited.
Then on execution quarterly deposit quarterly 25% is also permitted to be withdrawn by you. He has withdrawn that amount.
So totally how much money he has taken? 8 lakhs plus?
25% of the 18 lakh 93,000.
So about 4 lakhs. 8 plus 4, about 12 lakhs he has taken.
12 lakh.
So balance money he has to get.
The court, Your Honor.
You transfer it to the.
Like, comment.
But ಇದು arbitration ಗೆ ಹೋಗ್ಬೇಕು.
Not consider the fact that our defense was that dissolution deed is not.
That's a different matter. First thing is this. In execution proceedings, you admitted the dissolution existence of partnership till 17.3 para 41 line 1, 2, 3, 4, 5 from the bottom. 17.3 2012. So you can't approbate and reprobate.
No, we are not admitted, Your Honor.
That's what the learned judge has recorded, sir. He's a super time skilled district judge. Please have some courtesy.
Attention for him, Your Honor.
That's a different one. No. Please see 1, 2, 3, 4, 5, 6, 7th line. It is not, this is the finding of the court. It is not possible to conceive that how the parties could come to conclusion that their partnership business is making loss within 7 days.
That is
not possible, sir.
We have also produced the copy of the dissolution before the appellate court, lower appellate court, official court. We also got for dissolution of the amount of farm registered before the registrar firms. There is no copy was also produced. We have got all the originals, but.
Do you want to try section 89? See, there is something more than what is meeting the eye. We are also, usually these are matters which you can settle by section 89 CPC. Would you like to try that?
I'll consult the party. I don't understand.
See, now anyway, you have deposited 26 lakhs. If he is happy with that, close the matter.
Oh, because our contention that dissolution ಆಗಿದೆ, you are suppressed
See,
your.
12 lakhs has already been released in his favor. He has to get some more money,
Yes.
perhaps. According to him, it is 14 lakhs more. So you sit with, it's all right, we understand that. Rather than keeping the money in the court. See, parties must have it's only a custodian. The Registrar General is only a custodian, he holds it as an escrow. Why don't you talk to him and get the matter sorted out?
I'll consult.
Talk to your client, talk to this gentleman. Tell us at 2:30 if you can close, how much money,
Clear.
huh? Mobile phones. 1 minute, 30 seconds.
I'll come up for the court.
You will, they are all relatives?
Not related.
Not relatives. All right. You please talk to your client. Come back tomorrow. Tell how much money you will give it to him. We'll close the appeal here. You see, now the position is the findings are against you. If we dismiss it, then nothing further remains. But if Section 89 can work, talk to the client, your client and the opposite person. Come back tomorrow. How much money? If both of you agree, we'll close the appeal. All right. We have shown you what is against you also. Tell your client. Sir, ನಿಮಗೆ ರಿಲೀಫ್ ಬೇಕು. ಇವಾಗ ಅವರು 26 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ. ನಿಮ್ಗೆ ಅಷ್ಟು ಬರುತ್ತೆ, 76,70,000 ಇವಾಗ ಡೆಪಾಸಿಟ್ ಪ್ರಕಾರ. ಅವರು ಕೆಲವು ಪಾಯಿಂಟ್ ಇದೆ. ನಾವು ಇದನ್ನ ಅಡ್ಮಿಟ್ ಮಾಡ್ಬಿಟ್ಟು ರಿಮಾಂಡ್ ಮಾಡಿದ್ರೆ 10 ವರ್ಷ ಆಗುತ್ತೆ. ಅದನ್ನು ತಾವು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. ಎರಡು ಕಡೆ ಪ್ಲಸ್ ಅಂಡ್ ಮೈನಸ್ ಇರುತ್ತೆ ಇದರಲ್ಲಿ. ನೋಡಿ ತಾವು
ಅವೆಲ್ಲ ಇದಕ್ಕೇನು ಇದೆ
ನೋಡಿ, ನೀವು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಹತ್ರ ನಿಮ್ಮ ಹತ್ರ ನಾವು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಟೋಟಲ್ ಅಮೌಂಟ್ ಅಲ್ಲಿ 1 ಟೈಮ್ ಬರುತ್ತೆ. ನರಸಿಂಹಯ್ಯನವ್ರೆ 1 ಟೈಮ್ ಬರುತ್ತೆ ನೋಡಿ, 1 ಟೈಮ್ ಬರುತ್ತೆ. ಗಿವ್ ಅಂಡ್ ಟೇಕ್ ಮಾಡ್ಕೊಂಡು ಮಾತಾಡಿ ಅವ್ರ ಜೊತೆ
ಕೇಳಿ ನೋಡಿ, ಈ ತರ ಸ್ವಲ್ಪ ದಯವಿಟ್ಟು ಒಂದು ನಮ್ಮ ಮಾತು ಕೇಳಿ. ಈ ತರ ವ್ಯಾಜ್ಯ ಬಹಳ ದಿವಸ, ಒಂದ್ ಮಾತು ಕೇಳಿ, ನಾವೇ ಹೇಳ್ಬೇಕು ಅಂತಿದ್ದೀವಿ. ಈ ತರ ವ್ಯಾಜ್ಯ ಜಾಸ್ತಿ ದಿವಸ ಟೈಮ್ ಆಗ್ಬಾರ್ದು, ಪಾರ್ಟಿಗಳಿಗೆ ಅನುಕೂಲ ಆಗ್ಬೇಕು ಅಂತ Section 89 ಇದೆ. ಅದರಲ್ಲಿ ಸ್ವಲ್ಪ ಗಿವ್ ಅಂಡ್ ಟೇಕ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಮ್ಯಾಟ್ರು ಸಂತೋಷವಾಗಿ ಸೆಟ್ಲ್ ಆಗುತ್ತೆ ಇಬ್ರಿಗೂ. ಅದನ್ನೇ ನಾವು ಅವ್ರಿಗೆ ಹೇಳಿದೀವಿ. ನಿಮ್ ಕ್ಲೈಂಟ್ಗೂ ಕೇಳಿ, ಈ ವಕೀಲರಿಗೆ ನಿಮ್ಗೆ ಏನು ಖುನ್ನಸ್ ಇರಲ್ಲ. ಅವ್ರು ತುಂಬಾ ಒಳ್ಳೆಯವರೇ ಅವರು. ಹೌದು.
He speaks nothing. I'm connected with the case. Always he speaks every court here like this one.
Doesn't matter. All right. You do one thing. Please have a talk with him. We are requesting you. Please have a talk with the person outside. Talk to your client. ಇಲ್ಲ, ನಾವು ಇಷ್ಟರ ಬಗ್ಗೆ ಮಾತ್ರ ಹೇಳ್ಬೇಕು, ಅದು ಬೇರೆ. If you can sort it out, tell us tomorrow. We'll close the matter tomorrow. All right. As prayed for by Raghunath, 2 weeks to file objection to IA 1 of 24.
My lord, one submission, my lord, the respondent filed the exclusive petition, my lord, issue the arrest warrant, my lord, on 20th.
Then you should not precipitate.
My lord.
ಅಂತ ಇಲ್ಲಿ ಡೇಟ್ ತಗೊಂಡು ಅಲ್ಲಿ ಪ್ರೆಸಿಪಿಟೇಟ್ ಮಾಡಿದ್ರೆ
Kindly, he is tenant. ಕೊಡಿ.
One
petition.
Cost if you answer like this. Suit property ಏನು ಅಂದ್ರೆ ಇದೇನು ಮನೆನಾ ಅಂಗಡಿನಾ ಎಲ್ಲಿದೆ?
vacate site, my lord.
You everybody want to test ಏನ್ ಹೇಳಿ? What is the suit?
Lease dated, my lord, 18/10/2019, my lord.
What is the suit property, sir?
Scheduled property, my lord, vacate site, my lord.
Where?
The lease period, my lord, 9 years, my lord. The lease effect from.
So what do you do with the vacant property?
My lord, your construction, my lord, as per the lease condition, my lord, page number 60, kindly, my lord.
ಅಲ್ಲರಿ, ನಿಮ್ಗೆ ಅವ್ರಿಗೆ ವ್ಯಾಜ್ಯ ಏನಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅರ್ಥ ಆಗುತ್ತೆ.
ಖಾಲಿ ಸೈಟ್ ನಾನು ತಗೊಂಡು ಅದನ್ನ ಡೆವಲಪ್ ಮಾಡಿ ಮಂತ್ಲಿ ರೆಂಟ್ ಕೊಡ್ಬೇಕಂತ ಇದು ಲೀಸ್.
ನೀವು ಸೈಟ್ ಡೆವಲಪ್ ಮಾಡ್ತೀರಾ?
ಹೌದು.
ಮಾಡ್ಬಿಟ್ಟು
ಅದನ್ನ ಮಂತ್ಲಿ ರೆಂಟ್ ಅಂತ ನಾವು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ as per this lease ಕಂಡೀಷನ್ ಮೇಡಮ್.
ಮಂತ್ಲಿ ರೆಂಟ್ ಅಂದ್ರೆ
ಇದು
ಲೀಸ್ ಮೇಲೆ ಲ್ಯಾಂಡ್ ತಗೊಂಡಿದ್ದೀರಾ ನೀವು?
ಲೀಸ್ ಪೀರಿಯಡ್ ಮೇಡಮ್ 9 years ಲೀಸ್ ಪೀರಿಯಡ್ ಮೇಡಮ್. Per month rent 5,50,000 per month rent ಮೇಡಮ್.
5,50,000.
And the upper
ಎಷ್ಟು ದಿವಸ ಆಯ್ತು ತಗೊಂಡು?
lease commenced from 1/1/2020 ಮೇಡಮ್.
1/1/2020.
The premise was vacated on 1/3/2020 ಮೇಡಮ್. ಅಲ್ಲ 2 ವರ್ಷ ಪೊಸಿಷನ್ ಮೇಡಮ್.
2 ತಿಂಗಳು ಹೋಯ್ತು.
2 ತಿಂಗಳು ವೇಕೆಟ್ ನಾನು ರೆಂಟ್ ಕಟ್ಟಿದ್ದೀನಿ.
Who vacated? You vacated?
ವೇಕೆಟ್ ಮಾಡಿ ಅವಾಗಲೇ ಮಾಡಿದ್ವಿ 2021 ಮೇಡಮ್. the COVID period ಮೇಡಮ್. The schedule premises were vacated and hand over the position ಮೇಡಮ್.
Where is that record?
ಅಲ್ಲಿ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲ್ಲ. ಅಲ್ಲಿ arbitration not there is no appearance. The only one but within 2 months melod hard pass by the learn session court.
Expert order.
Yes melod. Only I have heard the wakalat. Then melod the apparent not appear. And 9/6/2023 melod why done?
And you can't execute it. Any compulsion. It is his land. You have gone there. You have contracted to build the property.
Getting in the
No, sorry, you.
2020 melod.
That's all. So let him file his counter objections. We'll see.
Actually, usually we have paid the
Deposit some money.
again, but 25% I have.
No, not possible. If you deposit money, we'll stop.
Only 2 months melod we have the portion of the
See,
land.
you are told that we are heard. We are not impressed by that.
The
Sorry,
respondent
2 weeks to
apparent-
file objections.
melod are
Sir, you have an option. If you deposit the money, we have
20% melod.
Agal rejected. 2 weeks. Next.
Usually arrest warrant melod
This court is unusual.
we can 50% melod we can.
Sorry. 50%.
50%.
Deposit. Bring the DD, stay.
4 weeks melod.
No, sorry. If you bring the DD, we'll give. No problem. Next.
Petition is
Hmm.
instructors because now it's a running lease.
Running?
Lease, very lease. But in this petition, they have challenged the demand notice of the year 2016. Every year audit report will be issued.
Correct.
Also, in the on 28/12/2023, a fresh audit report has been issued. He has to try, but if he wants to challenge, he has to challenge.
Correct.
My lord, sir, in earlier circumstances, your lordship.
Sorry.
Earlier circumstances, my lords, your lordship has passed the similar orders, my lords,
Saying what?
on the same demand of the royalty.
No, sir. See, he is correct because there will be an audit. This is a mines and minerals. Annual audit will be there. If you don't agree with the audit objection, you'll have to show me, you'll have to simply show them that, sir, I have made so much of payment. That's all. There's nothing in writ petition to be done here.
My lord, the copy is not at present.
Please go to the office. They will give you 10 copies.
Here it has been issued.
Still, I have no issue.
What is the prayer in this?
I am challenging the
1 minute, let us see.
Demand notice at annexure H.
Certiorari so-and-so verification of,
First,
oh,
to
sorry. sir.
Lease accounts.
Lease account cannot be quashed. It's an audit objection. You have to comply with the audit objection or must give an explanation to that. Aste.
But without giving notice, my lord, the direct.
That itself is notice to you. Sorry.
Demand itself a notice.
Writ petition is wholly misconceived. Perfect. This petition is presented with following prayers. Learned advocate for the petitioner the solitary contention that the audit report has been
For 2015.
for 2015 for financial year FY 2015-16
Verification dated
has been issued without issuing a notice to him. Full stop. Sri Mahendra, next line, Sri Mahendra Learned AG rightly submitted that it's a query lease, is it? Query lease is in currency. Every year, the audit report is prepared and sent to the petitioner. If petitioner has any objection, he may file the objection with to the audit objection.
Or if not, he can file revision also.
Or file a revision petition under section 50 of the 53 of KMC rules.
Yeah.
Full stop. It is not this next line. It is not dispute. Query is alva, running lease is alva. It is not disputed that the query lease is in currency. Full stop. In that way, the matter, this petition is misconceived, dismissed, no cost.
But my lord, with liberty to.
Always.
Please.
You always have the liberty. Next.
Matter arise of Industrial Disputes Act, my lord. If appellant is my lord, appointment working under the appellant, my lord. So provision 87, my lord. On the charge of bribe, taking bribe amount.
Request to my senior counsel before he starts the similar circumstances, there are undisputed tag on the same charge, my lord, on the same date. All similar, everything is similar. The person has taken a bribe from the senior officer. A junior worker has taken the bribe. That is the charge. In this case, my lord, I have already produced the.
Our copy kodi.
Objection is that man, they should have produced it before the single judge in the petition was heard.
Correct.
Larry has not produced it. No, the facts are slightly different, my lord. In the case of 2002, there was reinstatement. Now, these persons are reinstated in 2010. This respondent and another in another case. 8 years back, I guess, we are required to pay, my lord, as per the order of the London single judge. Well, this honorable court has stayed the recovery, I mean, the payment of money
already.
Sorry?
Produced ಮಾಡಿದ್ದೀನಿ ಅದ್ರಲ್ಲಿ ಒಂದು ಪ್ಯಾರಾ ಓದಿದ್ವಿ ಸೇಮ್ ಫ್ರಮ್ ಇದರಲ್ಲಿ ನನ್ನ ಈ ಕೇಸಲ್ಲಿ ಕನ್ಸರ್ನ್ ಆಗಿರೋದು 5,000 ರೂಪಾಯಿ ಬ್ರೈಬ್ ತಗೊಂಡು ಸೀನಿಯರ್ ಆಫೀಸರ್ ಇಂದ ಅಂತ ಈ ಕೇಸಲ್ಲಿ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ 15,000 ರೂಪಾಯಿ ಬ್ರೈಬ್ ತಗೊಂಡ್ರು ಅಂತ ಸೀನಿಯರ್ ಆಫೀಸರ್ ಇಂದ
ಮ್ಯಾಟರ್ ಹಿಯರ್ ಮಾಡ್ಬೇಕಲ್ವಾ ಅವರು ಅದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ನಾವು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಫ್ಯಾಕ್ಟ್ಸ್ ಆರ್ ಡಿಫರೆಂಟ್ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರಲ್ಲ.
ಫ್ಯಾಕ್ಟ್ಸ್ ಅಂದ್ರೆ ಏನು ಅವಾರ್ಡ್ ಯಾವಾಗ ಆಗಿದೆ ಇದು ಬೇರೆ.
ಅದನ್ನ ನೋಡ್ಬೇಕಲ್ಲ, ನೋಟ್ ಡೌನ್ ಮಾಡಿ.
ಅಲ್ಲ ಚಾರ್ಜಸ್ ಎಲ್ಲ
ಪ್ಲೀಸ್ ಡೂ ಇಟ್ ಇನ್ ಮಾರ್ಚ್. ಇಫ್ ಕಂಟೆನ್ಷಿಯಸ್ ಇಶ್ಯೂಸ್ ಟು ಬಿ
ಡೇಟ್ ಮಾಡಲ್ಲ ಬಿಕಾಸ್
we'll give a date.
87 ಅಲ್ಲಿ ಡಿಸ್ಮಿಸಲ್.
All right, 20th March. By consent.
I'm for the petition.
So Rajesh Bhatt, PIL. What is the PIL about?
My lord, the PIL is about upgradation of medical facilities at Bhatkal subdivision in Uttar Kannada district. Bhatkal revenue subdivision in Uttar Kannada district. Plus this PIL. Yes, my lord.
Who are you?
Doctor.
My lords, I am represented by a public charitable trust who is represented by its chairman, who is a medical practitioner for last 50 years.
Notice has been ordered?
Yes, my lord. On the last occasion, notice has been ordered, my lord.
Yes. Any reply you have filed? All right. Please
My
file
lord,
it.
my lords, one submission, my lord. In the meantime, annexure L might be seen. That is the reason why this petition is preferred, my lord.
What is annexure L?
It's a news item which shows that patients who are traveling from Uttar Kannada district to Udupi district met with an accident. The ambulance itself, there was one patient, however, 5 people were killed. And due to this, the petitioner is preferring this petition.
because there is absolute lack of medical facilities, my lord.
Fair enough, sir. That's what the government has to examine. It's a
Please,
policy
madam.
matter.
Oblige.
Let it GA 6 4 weeks time.
Proceedings 8 and 9.
Notice has not gone.
Notice has been issued to.
Notice has not been ordered.
My lord, notice has been issued to, yes, my lord, 6, 7, 8, 9
You
has
take
not been-
for whom, madam?
6, 8 and 9.
1 to 6, 8 and 9. All right, notice to order.
Please.
Oh, yes, Mr. Ramesh has taken time.
6th March.
Date was not, on his request, we consent to the date was.
We don't know.
Lordship may not be, this is allotment matter, Lordship may have it tomorrow or on.
Oh, not possible, sir.
On Monday.
Sir, please have some mercy. Thank you. What ASC, what is this matter about?
Challenging the order of the single judge, my lord.
You are also arguing like this. You must say the list. This is the matter. Of course, when you file an appeal, you will challenge the order of the honorable single judge.
Central employees are involved, or more than the employees, casual labor. Whatever we have brought in a scheme which is known as conferment of temporary scheme. That was initially applied, later on withdrawn without any reason in 2005. Again applied in, again made implemented in 2015. Our contention is that we are entitled to get the benefit of the scheme. After everything is approved by the ministry as well as by the board, they have straight away withdrawn that scheme without there being any reason. Later implement after 10 years in 2015 once again. That single judge has held that having regard to the fact that the committee was appointed, on their recommendation, board agreed, approved by the ministry, then there was no reason for you to just withdraw it without any reason. That is the benefit, about 1,000 employees of state board are involved throughout the country. You would request that time permit, otherwise you will not be put.
Not possible. You can choose a date, we'll give 20th March or something. March 20. We don't know how the board will be adjusted. You can move them.
CJT order.
Learned that we said that the Chair K, the college has recommended to grant additional grade pay, not increasing, they were drawing at 6,000 grade pay.
Part-time lecturers.
Recommended to get. This court has said one small question regarding framed earlier at the time of hearing.
Sir, 23 appeal for preliminary hearing. The best we can give you an order is admit. You don't want admission, we can't do.
Call it along with the appeal number 11.
All right, as prayed for, call along, post along with such and such appeal.
4 of 23, not by first week of March.
Sir, we cannot fix the board of,
Matter is not yet admitted.
that's right, post along with such and such. Yes, Muralidhar. Yes, please.
This is the DRT matter, my lord. Even in the last occasion, I had
Implement.
submitted. There are 4 loan accounts. The property which I have to say, we have recovered 1,92,51,000, which we have adjusted towards 3, partially towards third. There is still balance of 49,67,700.
Still
There's still balance of 49 lakhs.
49 lakhs.
And
They have to pay.
they have to pay, and there's a dispute between first line and second line. If they pay both come together, Manoj, we have no objection to release the property. Out of 3.
No. According to you, they still owe you 49 lakhs.
Out of 3 properties, 2 have been sold, 1 is still with the custody of the bank.
So if they pay 49 lakhs, you will give back the property.
And there is a dispute between first wife and second wife, both come, Manoj, we will release. If I release, Manoj, to the second wife.
Only section 89.
My lord, with regard to this, the subsequent advances or the prior advances whatsoever they have been made, that cannot be, the properties cannot be attached to that unless there is a specific lien for the properties. So that is not done, my
We
lord.
are afraid we may not be able to appreciate that because there is a banker general lien. in it.
No, actually, the specific lien must be there for that. Unless that is there, they cannot withhold the properties.
Maybe a wrong consideration, but we are clear that the bankers can exercise lien.
No,
Sir, you must examine the position of law. You are arguing in the writ appeal in court 1 in the High Court.
Yes,
You must position, at least kindly look up Contract Act, bankers lien, then you can come back.
Come up with the citations also, madam.
Saying,
Whether this, the subsequent advances or the prior advances can be, the properties can be attached to that. That cannot be done, my lord, unless there is a specific lien for the properties particular to that advancement. That is not done. When that is not done, that cannot be possible. They cannot attach my other.
then please give the citations to him, let him come back. Yes. Sri so-and-so, learned advocate for the appellant submits that the bank has sold the properties for an excess of
Excess of the
the total
outstanding.
debt for an excess,
Outstanding.
the total outstanding.
1 crore 23 lakhs.
1 crore, the appellants out was due and liable to pay rupees 1 crore 23
3 lakhs.
whereas the bank has sold properties, 3 properties worth more than
3
prop-
properties,
two-
3 properties, my lord, that has been with the bank. 3 items.
So sold.
They have
One
sold
is
2.
with them.
Yeah, 2 properties they have sold and 1 property.
Appellants have had mortgaged 3 properties. Out of them, 2 properties have been sold for rupees 1 crore 92 lakhs. Full stop. Sri Jeevan Kumar submitted that the appellants have taken, have availed different loans and bank has adjusted, has closed the said loans also. Full stop. According to Mr. Muralidhar, such act of the bank is illegal and contrary to the law laid down by the apex court. He has furnished the authorities to Sri Jeevan Kumar for full stop. As prayed for, and Jeevan Kumar seeks time to examine the same. Call on 20th March.
Let it be on any other date, please, my lord.
Any other date, whichever the date you want.
Prior to that or after that?
All right, you take whichever the date you want. By consent, call on such and such date.
18th or 19th.
Please give it to the court officer. It will be recorded. Yes, M. Krishnappa.
Climbing is, in the climbing.
It's running up the bar of police.
Cut, copy, paste order. Sorry, no contempt in this.
ಅದೆಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದೆ ನೋಡಿ, ಪೇಜ್ ನಂಬರ್ 16 ಅಲ್ಲಿ ನೋಡಿ, ದಿಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ಫಾಲೋಡ್. ಇನ್ಫ್ಯಾಕ್ಟ್ ನಂದರಲ್ಲಿ ಪ್ರೇಯರ್ ನೋಡಿ.
ನಾವು ತಮ್ಗೆ ಸೂಕ್ಷ್ಮವಾಗಿ ಹೇಳಿದ್ವಿ, ನಮ್ಗೆ ಅರ್ಥ ಆಗಿದೆ, ನೋ ಕಂಟೆಂಪ್ಟ್.
ಸ್ವಾಮಿ, 1 ವರ್ಷದಿಂದ ನಮ್ಗೆ
ಏನ್ ಮಾಡಿದೆ?
ಆರ್ ನಾಟ್ ಬೀಯಿಂಗ್ ಅಲೋಡ್ ವೆನ್ ದರ್ ಇಸ್ ಅ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಇದು ಗ್ಯಾರಂಟಿ.
No, why have they locked your business premises?
ಲಾಕ್ ಮಾಡಿ ನಮಗೆ 19
ಅಲ್ಲ ಏನಾಗಿದೆ ತಮ್ಗೆ ಅಂತ ಕ್ಲೋಸ್ ಮಾಡಿದಾರಾ?
ಹೌದು ಸ್ವಾಮಿ, ದೇ ಆರ್ ನಾಟ್ ಬೀಯಿಂಗ್
ಯಾಕ್ರಿ?
ಅಲೌಡ್ ಟು ವರ್ಕ್, ದೇ ಆರ್ ನಾಟ್ ಬೀಯಿಂಗ್ ಅಲೌಡ್ ಟು ವರ್ಕ್.
They are preventing live band. They wanted to.
No, it is not live band. Your lordship may kindly see my prayer in the writ petition, my lord. Women are being not allowed to work. That is my prayer. They have admitted, no, we will not.
All right, file your counter.
Live
All right.
ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ ಅಂತ.
All right, file your counter. Sri Mahendra appears ಯಾರಿದ್ದಾರೆ? R9.
ಅಲ್ಲ ಎಲ್ಲ ಪೊಲೀಸ್ನವರೇ ಸ್ವಾಮಿ, ಎಲ್ಲರೂ ಪೊಲೀಸ್.
Notice ಕೊಡ. Your submission that you are not stopping there or you are not stopped their locked their premises. You have such instruction?
Over telephone and. That may kindly have it tomorrow. I will keep the jurisdictional inspector present for.
ಆಗ್ಬೋದಾ? ಆಯ್ತು. ಅವ್ರು ನಾವು ಕ್ಲೋಸ್ ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ ಆಯ್ತಲ್ಲ.
ಮಾಡೋದಲ್ಲ ಸ್ವಾಮಿ, ವುಮನ್ ಆರ್ ನಾಟ್ ಬೀಯಿಂಗ್ ಅಲೌಡ್ ಟು ವರ್ಕ್ ಇನ್.
ಅದನ್ನ ನಾವು ಇಲ್ಲಿ ಎಡ್ಜುಡಿಕೇಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
This honorable courts are there and the honorable Supreme Court has said that women have the right to choose their employment. It has been permitted under the Constitution 19(1)(g). Following the Supreme Court judgment, we are.
All right. ಅಂದ್ರೆ tomorrow ಬೇಡ. Tomorrow ಬೇಡ. Next one day ನೀವು ನಿಮ್ಮ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ. ಪೋಸ್ಟ್ it. First week or second week of March. Yes, next. Learned speak ಬರ್ಕೊಳ್ಳಿ. Sri Mahendra accepts notice for R9 and seeks time. Full stop.
Engage senior counsel. Engage senior counsel.
Next week ಆಗಲ್ಲ ಸರ್. ಇರ್ಬೋದು ಬಟ್ ಇಲ್ಲ ಕೃಷ್ಣಮೂರ್ತಿಗಳೇ, ಸಾರಿ. Learned advocate for appellant seeks time, call on such and such date. ಕೃಷ್ಣಮೂರ್ತಿಗಳದ್ದು ಅಪಿಯರೆನ್ಸ್ ಬರ್ 54.
Dream order may extend.
Yes, always. Whatever the order is there. ನಾವು ಅದನ್ನ ಟಚ್ ಮಾಡಕ್ ಯಾರೋ ನಾವು ಕೊಟ್ಟಿಲ್ಲ ಅದನ್ನ.
ನಾವು ಕಟ್ಟೆ ಆಗಿತ್ತು. Application also for vacating.
ತಮ್ಗೆ ಅರ್ಲಿಯಸ್ಟ್ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಬೇಕು.
By virtue of 11 is said it is already been executed. Now that
ಅದೇ ಅದ್ರ ಬಗ್ಗೆ ಚೂರು ಬರ್ದು ಕೊಡ್ಬೇಕಲ್ವಾ, ಸ್ವಲ್ಪ ಹಿಯರ್ ಮಾಡಿ ಬರ್ತಾರೆ. ಎಸ್, ಥ್ಯಾಂಕ್ ಯು. ಎಚ್ ಪ್ರದೀಪ್ ಕುಮಾರ್. All right. As prayed for by Sri Sabrad Larat, Senior Advocate, post along with writ appeal number such and such.
88 of 2023.
Yes.
And contempt is number 69 of 2023.
Yes, yes. Right. Thank you. Shauri.
Milords, I appear for the petition, Milords. In this matter, state is supposed to file a report, Milords. They have done inspection, Milord. Last time also I made a submission. I was present. They were supposed to.
Who appears in 55 government?
Time.
Report. Report, madam.
I'm submitting this.
You are appearing for R5. Yeah, all right. Have you filed or filing? File it in the office. Learned advocate for R5. Your yes, Vidya. Vidya, learned advocate for R5. Submits that report will be filed in the registry today. April and date. Which one? 50?
58 ಅದೇ
58.
ಮರಳು ದುಡ್ಡು ಕಟ್ಟಲ್ಲ ಮರಳೆ.
ಏನಂತ?
That my lord, they without hearing, my lord, without giving any opportunity, my lord, they can't pass this kind of an order. See, my lord, please come to my lord, please. In this demand notice, my lord, page para 2, last 5 lines. Respondent issued a demand notice, my lord, demanding 75 lakhs.
That's all right, but in this case, what are the facts?
In this case, my lord, they, my lord,
Where is that order? What are you challenging?
running page 83.
No, what are you challenging? First, let us see.
83, my lord. Annexure G. They, somebody gives a complaint and my lord, they say that we have conducted some matter and then nothing is given to us, no notice, no show cause notice. No notice. Straight away, my lord, they say that.
Notice ಹೆಂಗ್ ಕೊಡಕ್ ಬರ್ತಾರೆ? Illegal.
Now we remember, we had asked, you are not there on the last date of hearing.
My
Yes.
colleague was there.
We had asked, and you disown the so much of sand. You say that, sorry, this is an illegal mining, the department has caught.
Caught.
You can have one stand. Sir, this is my sand. I'm prepared to pay some money or fine, etc. That's a different matter. Otherwise, disown it.
Lord, I asked myself this question. Can they pass an order without even hearing us, without even notice, without my lord show cause notice?
Can we pose a counter question?
See, my lord, who was given the complaint? Please come to my lord, running page, my lord, 83. Third line. One Ningegoda, Mali Patil and our Manjura, the Pradesh, Anjalikrita, Sada Marudu Martha.
There can be CO moto. Supposing on a road, on a river side, there are about some 100 truckload of sand is there. They are entitled to recover it. No question about it.
Lord,
If you own the sand, if you say that, yes, sir, I am owning.
I had a lease. My lord, I am the leaseholder. Please come to my lord, running page, my lord.
This is a standard answer, sir. People will have lease in survey number 1. They do leasing extraction in survey number 2.
This order of justice, where my lord, his lordship, my lord, has held.
These are all on facts, sir.
Correct, my lord. On the facts only.
If you are prepared to deposit some money, we'll consider, not otherwise. At least we are very clear on.
Lord, I am willing to deposit, my lord, 10%.
What is the value of the sand?
Total. They say that, my lord, 1,44,000
lakhs. 1 crore 44 lakhs, 30,000.
No, 1,444 lakhs, my lord, is the danda.
How much is the value? Sarkardavare?
Sarkarada idu ಎಷ್ಟು? 1 minute, I say, what is the value ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. My lord, 29 lakhs 25,000. ತಮಗೆ 1, 2, 3, 4 ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ನೋಡಿ
25 lakhs.
ಆಮೇಲೆ ದಂಡ ಹಾಕಿರೋದು ಅಷ್ಟೇ.
ದಂಡ ಆಮೇಲೆ ನೋಡೋಣ.
29 lakhs.
29 lakhs. 30 lakhs ಗೆ ಎಷ್ಟು ಕಟ್ತೀರಾ ಹೇಳಿ.
My lord, can I submit this 20% ಅಂತ ಹೇಳಿ.
Total demand is large.
Total demand
penalty is an adjudicatable factor.
ಯಾವುದು ಕೇಳಲಿಲ್ಲ, ನಮ್ಮನ್ನ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ.
19
I leave it to your lordship, my lord. Whatever your lordship needs, just.
At least.
How much demand is there?
29 lakhs 25,000 is.
ಅಲ್ಲ ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟಿದೆ?
1,44 ಲಕ್ಷ.
ಅದು ದಂಡ 5 times, my lord.
45 lakhs. ತಾವು 10% ಅಂದ್ರೆ 14 lakhs ಆಯ್ತು ನೀವು ಹೇಳ್ದಂಗೆ.
ನಾನು ಇದಕ್ಕೆ 29 lakhs ಇದ್ದು 20% ಕೊಡ್ತೀನಿ, 25% ಕೊಡ್ತೀನಿ. This is the amount, my lord, even according to.
Alley of this and 29 ಲಕ್ಷ.
25.
How can they, my lord, quantify without?
Alley of this and ಕಟ್ಟಿ ಆಮೇಲೆ.
There are 2 other judgment of justice, the other division bench also.
This is not
Justice
ಕಟ್ಟಿ ಅಂತ ಹೇಳಿ.
This is
royalty.
that we'll see that. That's a different matter. But you must be solvent, because we will tell you, sir, the paying that 10 lakhs, 20 lakhs, taking away the sand, government will be left high and they can't recover money at all.
What is the value? Even according to them, my lord, it's 29 lakhs.
But what about the crime? The penalty is exactly. So you are owning up you want the sand. You don't want to, you are owning up the sand, but you don't want to face the consequence. That is not possible.
And ಸಾಗಾಣಿಕೆ ಆಗಿದೆ ಅಂತ ಹೇಳಿ. It is not that, my lord, ಅಲ್ಲಿದೆ ನಾನು ಹಿಡಿದಿದ್ದೀನಿ ಅಂತಲ್ಲ. Please look at it. ಸಾಗಾಣಿಕೆ ಆಗಿದೆ.
ಹೌದು, ಈಗಾಗಲೇ ಹೊತ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. 27,950.
ಸಾಗಾಣಿಕೆ ಮಾಡಿರುವ
3,698 ಟನ್ ಇದೆ.
Then that let the government keep it with themselves. Last first para end ಅಲ್ಲಿ ಪರವಾನಗಿ ಪ್ರದೇಶದಲ್ಲಿ ನಿರ್ಮಿಸಿದ ಶೆಡ್ ಹಿಂಭಾಗದಲ್ಲಿ 3700 ಮೆಟ್ರಿಕ್ ಟನ್ ದಾಸ್ತಾನು ಮಾಡಿರುವುದಾಗಿ ಮಹಜರ್ ವರದಿಯಲ್ಲಿ ಸೂಚಿಸಲಾಗಿದೆ.
ಇದು ಎಲ್ಲಿದೆ ಅಂತಾನು ಹೇಳಿಲ್ವಲ್ಲ.
ಬೇಡ, ನೀವು ಬಿಟ್ಬಿಡಿ ಅದನ್ನ, ನಿಮ್ದಲ್ವಲ್ಲ ಅದು. That is precisely the question we had asked the learned advocate. If you say that the property is mine, deposit the money.
Can I persuade your lordship? Just look at that sentence again.
Yes, yes.
ಸದರಿ ಮರಳು ಪರವಾನಿಗೆ ಪ್ರದೇಶದಲ್ಲಿ ನಿರ್ಮಿಸಿರುವ ಶೆಡ್ ಹಿಂಭಾಗದಲ್ಲಿ. It's not in my own property. I am entitled. Please look
in
at
a writ jurisdiction, we cannot record such findings.
My lord, according to them, this is, my lord, valued at 29,25,000. Whatever your lordship feel, just, my lord, I don't want to, my lord, bhari.
My lord, the
court might be so.
Yes, next.
Lord, there was a lease deed, there was a renewal license, renewal clause. COVID time, hospital ನಡೆಸ್ತಾ ಇದೀವಿ.
ತಾವು ಹಾಸ್ಪಿಟಲ್ ನಡೆಸ್ತಾ ಇದ್ದೀರಾ?
It's called the essential hospital.
Hmm.
We have deposited, we have spent over nearly about 3.5-4 crores for redoing the whole thing. Thick of COVID, the agreement specifies that we'll have to issue notice, 3 months prior notice.
ಇವಾಗ ಏನಾಗಿದೆ ತಮಗೆ?
3 months notice ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಒಂದೇ ತಿಂಗಳು notice ಕೊಟ್ಟಿದ್ದೀರಿ, therefore eviction order.
It is no notice issued, my lord, sir. It is the lease expired on 30th November 2021. It wanted renewal, they were to seek renewal, expressing their intention 3 years prior to the expiry.
3 years.
3 months prior to the expiry. They did not do it. On 25th October 2021, I issued a notice saying that I have no intention to renew, please vacate by 30th November. Thereafter, they write a letter. I have already requested it. The arbitrator has considered all the things.
ಇವಾಗ ಏನಾದ್ರು ತಾವು ಬಾಡಿಗೆ ಕೊಡ್ತೀರಾ ಅವ್ರಿಗೆ ಅದನ್ನ?
ಬಾಡಿಗೆಗೆ last time ತಾವು ಪ್ರಪೋಸಲ್ ಹೇಳಿದ್ರು. ಅವರು 2 ವರ್ಷ 3 ವರ್ಷ ಅಂದ್ರೆ ಎಷ್ಟು ಕೇಳ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ ಒರಿಜಿನಲ್ 2021 ಇಂದ
ಎಲ್ಲಿವರೆಗೂ?
ಅವರು their term expired on 30th November
5 years renewal ಇದೆ ಸ್ವಾಮಿ. ನಾನು ಅಷ್ಟೇ ಕೇಳೋದು.
Already-
ನಾನು have spent. Please come to page 200 of the.
ಅಲ್ಲ ಅದೆಲ್ಲ ಬರೋಣ, ಅವ್ರೇನೋ ಹೇಳ್ತಾರೆ, ಒಂದ್ ನಿಮಿಷ ಹೇಳಿದ್ರು.
My apologies.
ಹೇಳಿ.
Yes, spent on my premises.
ಅಲ್ಲ ಇರ್ಲಿ, ಅವ್ರದ್ದು ಲೀಸ್ ಅಲ್ಲ, ಅವ್ರ ಲೀಸ್ ಯಾವಾಗ ಮುಗ್ದಿದೆ ಅದು ಹೇಳಿ.
Structure he has put up, that also has been answered.
ಫೇರ್ ಎನಫ್. ಅವ್ರ ಲೀಸ್ ಮುಗ್ದಿರೋದು ಯಾವಾಗ?
30th November 2021.
30th November 2021.
Even if they had renewed, it would have expired on 30th November 2026.
26.
Already 2 ವರ್ಷ
5 years add ಆಗಿದೆ.
they have enjoyed it. 3 ವರ್ಷ ಕೊಡಿ, 4 ವರ್ಷ ಅಂದ್ರೆ ಒರಿಜಿನಲ್ ರಿನ್ಯೂವಲ್ ಕ್ಲಾಸ್ ಗಿಂತ ಬಿಯಾಂಡ್ ದಟ್ ದೇ
ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನು
ಅಲ್ಲ ಇವಾಗ
I have given.
ಇವಾಗ ಅವ್ರಿಗೆ ಎಷ್ಟು 26 ವರೆಗೂ ಬೇಕಾ?
They are asking about
ತಮ್ಗೆ ಎಲ್ಲಿವರೆಗೂ ಬೇಕು ಸರ್ ಇದು?
26 ವರೆಗೆ ಕೇಳಿದೀವಿ ಸ್ವಾಮಿ. ನಾವು ತಮ್ಮ ಇದ್ರಲ್ಲಿದ್ದೀವಿ, ಅವ್ರ ಅಲ್ಟಿಮೇಟ್ಲಿ
months ಅಂದ್ರೆ ಇರಿ
January. They were
COVID. We are treating.
ಅದೇ ಅವ್ರು ಎಷ್ಟು ಕೊಡ್ತಾರೆ ಕೇಳೋಣ ಪಾಪ. ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಹೇಳಿ?
30th January.
Of?
Vacate according to the order of the award of the arbitration. Another 6 months.
6 months ಅಂದ್ರೆ it will be July. So ತಾವು
25
Today I am billing.
ಅದೇ
ತಿಂಗಳಾದ್ರಲ್ಲಿಗೆ 26 ಬಂದು
ತಮ್ಗೆ ನವೆಂಬರ್ 26 ವರೆಗೂ ಬೇಕು. ಇದು ನಾವು ಆರ್ ಇನ್ ವಾಟ್ 24.
It is reasonable, it will be
ಅಲ್ಲ
reasonable.
ಅವ್ರು ಹೇಳಿದ್ದು
ನಡೆಸ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ. That's all.
ಆಯ್ತು. ಇವಾಗ ಸರ್ ನಾವು ದಟ್ ದಿ ಡಿಫರೆನ್ಸ್ ಇಸ್ ವೆರಿ ನ್ಯಾರೋ. ಸೊ ಅಲ್ಟಿಮೇಟ್ಲಿ ಎಷ್ಟು ದಿವಸ ಬೇಕು ಕೇಳ್ಬಿಡಿ, ಒಂದು ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡಿ. ಕೇಳಿ ಎಷ್ಟು ದಿವಸ ಬೇಕು ಅಂತ.
Of course.
ಎಷ್ಟು
ಅಂದ್ರೆ 1-2 ವರ್ಷ ಆದ್ರೂ ಕೊಡ್ಲಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು. ಅಂದ್ರೆ
ಸರ್ ಒಂದ್ ಕೆಲಸ ಮಾಡಿ.
2 years from 30th November 2000.
ಅಲ್ಲ ಕರೆಕ್ಟ್. ಇವಾಗ ಒಂದು
ಇವತ್ತಿಂದ 2 years ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀವಿ. 26 ಜನವರಿ ಅಲ್ಲಿ
ಅವರೆಲ್ಲ ರಿವೈಸ್ ಮಾಡ್ಕೊಳ್ಳಿ ರೆಂಟ್ ಬೇಕಾದ್ರೆ.
ನಾವು
ಇನ್ನೊಂದು
ನಾವು ಒಂದು 6 ತಿಂಗಳು ಹೇಳಿದಿರಾ, ಅವ್ರು 2 ವರ್ಷ ಕೇಳಿದ್ದಾರೆ, 1 ವರ್ಷನೋ 1.25 ವರ್ಷನೋ ಕೊಟ್ಟು ಕ್ಲೋಸ್ ಆಗ್ಬೋದಾ?
1.5 ವರ್ಷ ಮಾಡ್ಕೊಳ್ಳಿ.
ಆಲ್ರೆಡಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ 1.5 ವರ್ಷ.
I have entered into an agreement of sale. I
he
build
can enter into agreement with taking my property.
ಇಲ್ಲ ಇಲ್ಲ
They are the-
This is not a matter to 1 year and 6 months close. After arguing the matter for some time, the Sri whatever
whatever rent the
as per the
award.
Award. Sri Rajagopal Learned Senior Advocate submitted that in his usual fairness, submitted that that appellant may be directed to vacate the premises within 6 months from today. Full stop. On instructions, Sri Holla, Learned Senior Advocate for the appellant, sought for 2 years. Full stop. After detailed deliberations, after substantial hearing, it was suggested by this court that 1 year and 6 months would be 18 months from today would be appropriate. In their as always, as fair senior advocates, both the learned advocates agreed. So and so shall file an affidavit. Appellant shall file an affidavit of undertaking to vacate the premises within 18 months with effect from today, without driving the petitioner, the landlord for execution, and to pay the rents as per the award. All other conditions. As per the award. Yes. Affidavit of undertaking within 4 weeks from today. Appeal disposed of.
Appear on behalf of respondent number 4.
1 minute. Adenu Mahendra. Kodsi. Copy of Mahazar and other documents relied upon by the deputy director has not been furnished. Mr. Mahendra assures that all papers shall be made available. Yes, next.
I appear on behalf of respondent number 4.
The copy today, I take 1 week's time to file my objection. Time, date will fix next week.
Learned advocate for caveator is seeking a week's time, Mr.
Yes, Lord. Even my lord, we'll also file our objection, Lord, because I am also the lessee.
No, you are appearing for whom?
Respondent number 4.
I was the appellant, sued for a specific performance of an agreement to lease. The suit scheduled property is in the 11th main of Jayanagar. For a fashion apparel, it was agreed to be leased to me. The agreement says the title is Memorandum of Understanding. The learned judge, Millard, says Memorandum of Understanding are made only internationally, not for the
Not any person.
Millard misdirects himself. The agreement has all the characters of an enforceable contract.
So you wanted a property on lease?
Yes. And Millard, during the existence of this agreement, Millard, a part of the property was leased by response 1 to 3 behind my back in favor of response number 4. And I had an injunction.
Who is for R4?
Lord, I appear for respondent number 4.
Who is for the landlord?
1 to 3 of the land.
What do you say? Why do you get into MOUs and don't honor them? No. See, that's a different matter. Refunding comes that prima facie you agreed to give the property. And then, no, I will not stand by that, take your money. And this is not correct. Why did you take money, sir? Sir, refunding is stage 2. Accepting is stage 1. Then? Anyway, they want some time.
Yes.
You are for the present occupant,
Yes,
is it?
Yes, Lord, because we have already spent 3 crores and from our shop is running.
All right. 6th March. Learned advocate for R5 seeks time to file objections. All right. 1, 2, 3 and 5 seek time to file objections.
Let not 1, 2, 3 response create further income.
ಅದು ಮಾಡಬಾರ್ದು ನೀವು ಅಲ್ಲ ಅರ್ಧ ಕೊಟ್ಟಿದಾರಂತಲ್ಲ
ಅರ್ಧದ ಮುಕ್ಕಾಲು ಕೊಟ್ಟಿದ್ದಾರೆ
ಇನ್ನೊಬ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ
R4 ಕೊಟ್ಟಿದ್ದಾರೆ
ಫುಲ್ ಕೊಟ್ಟಿದಾರ
ಅಲ್ಲ 75% of the property is leased. For 3 times of the rent that I agreed to pay.
No, but that is why they have refunded them. ಇವಾಗ ತಮ್ಗೆ 25% ಪ್ರಾಪರ್ಟಿ ಬೇಕಾ ನಿಮ್ಗೆ ಬೇಡ ಅಲ್ವಾ
On the 12th May, I don't know
ಏನು ಮಾಡ್ಬೇಡಿ
whether my client is interested. Let them file objection.
All right. 6th objections.
But my lord, ultimately, my lord, the findings recorded by the learned judge will have to be, my lord, set aside. He says that is not an enforceable contract. My suit is still remains. We are at the stage of interlocutory application. I had an my lord, injunction, ex parte injunction, which has been now dissolved after hearing the parties.
Right. Thank you.
Please, oblige.
Thank you.
Hello, 61 Naganand ಅವರು ಇದ್ದಾರೆ.
I appear, my lord, in 61. Matter had been
What is this
heard, my
matter?
lord. My lord, this is a case where the charge is claimed against two officers of BDA, the joint director and assistant director, on the ground that permission from KIADB, NOC, was not obtained. Your lordship saw, my lord, on the last occasion, there is a letter from KIADB saying that NOC is not required because they've already sold the property. Page number 39.
No.
37.
Now, no, 1 minute. You are case at.
There are two appellants, my lord. They are both senior officers. One is a joint director and the additional director in the BDA.
So what has happened now? What are you
My lord, what
challenging?
has happened is, my lord, they instituted, my lord, inquiry proceeding against me on the ground that without obtaining an NOC from the KADB, the BDA has granted approval of layout. The submission, my lord, that I had made was that this land, my lord, which was allotted by KADB several years ago, after full compliance, the sale deed has been executed by KADB, absolute sale deed in favor of the Joy Ice Cream, who, my lord, entered into a joint development with another company, and they had asked for layout. It's covered by judgment.
1 minute.
The lordships had posed a question to the other side. What is it that my clients were required to do which they did not do? Because the matter is covered by a judgment of the learned single judge, my lord, holding that once an absolute sale deed is executed, no question of NOC. And this very grant in favor of Joy Ice Creams was subject matter of a challenge before this honorable court. Honorable division bench, my lord, has examination.
No. Let us get the facts right. See, the property was owned by whom?
My lord, the property was allotted to an entity called Joy Ice Creams, my lord, by KADB.
Right.
For industrial purpose.
Right.
And Joy Ice Cream, my lord,
1 minute.
the-
1 minute. KIDB to Joy. Then?
Yes. That was in the year 2007. Then, my lord, the Joy Ice Creams, my lord, had complied with all the terms and conditions, and an absolute sale deed dated 21/7/2006 was executed in favor of Joy Ice Creams.
Right.
Then, my lord, this Joy Ice Cream, there is a list of dates, my lord, I have given. Maybe your lordships, if you could see that, it gives all the dates also.
No, we will see, but just tell us in brief so that we
Yes, my
then
lord.
we will
Then what
recollect.
happened, my lord, was this. An application was made for approval of a layout sanction to be given from the BDA, which is the planning authority for this area. Initially, my lord, the BDA,
So BDA has given the approval or not given
yes,
the
BDA gave the approval, my lord, on 20th of August 2008. Thereafter, my lord, 2 years later.
So what is the problem now?
2 years
What is the
later,
problem?
some mischief monger, my lord, engineered a news report to say that this grant of land to Joy Ice Creams was illegal because this land was acquired for industrial purpose. That was the mischievous report that was given. Based on that, my lord, a suo motu inquiry was done by the Lokayukta, And they decided to institute inquiry against me. We am the officers of the BDA on the sole ground that we did not obtain an NOC from KADB before the BDA approved this proposal. Not record shows that before the matter was approved by the KADB, the issue goes before the KADB. KADB write a letter to say that since sale deed is executed, no approval is needed from us.
Where is that?
That is on page 39, my lord.
Page
Just
39.
Sorry, 34, my lord, 34. 5/6/2008. This is before the BDA approves it.
Like to state that the lands were allotted to
KADB.
as back as the implementation of the project. These are also in your letter you have indicated that the BDA accorded change of land use since KADB has already issued sale deed. Approach BDA only for matters pertaining to change in land use, etc.
Yeah. After this, my lord, the matter goes before the BDA, and the resolution of the BDA, my lord, is at page 39. They examine all this, and please see, my lord, at page 40, who are all present. These two officers, my lord, are lower level officers. They are not even members of the authority. The approval is at page 39.
Yes,
First para.
Yes.
Agenda nalli Bengaluru Taluku survey number ella ಹಾಕ್ತಾರೆ. ಆಮೇಲೆ ಸಮಿತಿ ಸಭೆ ಮುಂದುವರಿಸಲಾಗಿ ಟಿಪ್ಪಣಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಚರ್ಚಿಸಲಾಯಿತು. ಚರ್ಚೆಯ ನಂತರ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು KR ನಗರ್ ಹೋಬಳಿ ಸೋಣಸೋರಲ್ಲಿರುವ ಪ್ರದೇಶದಲ್ಲಿ ವಸತಿ ಉದ್ದೇಶಕ್ಕೆ ಅಭಿವೃದ್ಧಿ ಯೋಜನಾ ನಕ್ಷೆಯನ್ನು ಕೆಳಕಂಡ ಷರತ್ತುಗಳೊಳಪಟ್ಟು ಮತ್ತು ಪಾರ್ಕ್ ಜೊತೆಗೆ ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ಬರುವ CA ಪ್ರದೇಶಗಳನ್ನು ಸಹ ಫುಕ್ಕಟ್ಟೆಯಾಗಿ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಹಸ್ತಾಂತರಿಸಬೇಕೆಂದು ಷರತ್ತಿನೊಂದಿಗೆ
ಆಯ್ತು. ಮುಂದೆ ಏನಾಯ್ತು?
ಇದಾದ್ಮೇಲೆ this inquiry, my lord, results in a notice issued to me to say that you have not placed all the material and you have not got this NOC.
Where is that notice?
My lord, page 68 is the notice issued. My lord, I should tell you, lordships, after that, my lord, inquiry was conducted, and the matter reached the Honorable Appellate Tribunal, and the Appellate Tribunal, my lord, quashed this entire proceedings at page 111.
Which proceeding?
This entire inquiry was quashed. At page 111, the inquiry order begins.
You are a party there?
Yes, my lord, just on my instance. Then, my lord, what happened? The operative portion of that is at page 128, my lord.
128.
Yeah. Para 11. The consideration on this issue. Learned government advocate produced the relevant file. We have perused the same.
Yeah.
Documents disclose that unanimous decision has been taken by the committee of BDA comprising town planning member, chairman of BDA. Sale deed already executed in favor of the firm. Consequently, there was no need to issue no objection.
Yes,
then, my lord, this order was challenged before this honorable court. And this honorable court, my lord, before the court, there was a procedural irregularity was what was pointed out. So this honorable court, my lord, allowed the writ petition and remanded the matter back to the authority, that is to the KAT. That is, my lord, at page 134. Pursuant to that, the KAT has now passed an order rejecting my application and holding that inquiry should go on. My lord, I have only two submissions to make, my lord. If your lordship could please turn to page 172. There is a judgment of the learned single judge in identical circumstances. When a sale deed is issued, should an NOC be sought? If your lordship could please go to the end of the judgment at page 179. 179, para 10.
Right.
The requirement of NOC in note B of revised master plan apparently is in the case of allotment made by government agencies like KADB, KSIDC. The case of petitioner is one of the allotment followed by conveyance of absolute title and possession of the plots of land and a sale deed. In other words, NOC is necessary if it's allotment by government agencies like so and so, not in cases where government agencies have executed conveyance deed for valuable consideration, divesting the right title interest in the movable property. It is in such cases that the requirement to comply with clause B of note so and so inapplicable. In that view of the matter, direction of the respondent to secure NOC from KADB is unnecessary and inapplicable. Identically same thing. No, my lord, in addition, what happened in this was they challenged, my lord, this allotment in favor of Joy itself was challenged. That matter, my lord, came before the Honorable Division Bench, and the Lordships, my lord, said that there is nothing wrong with the allotment, and the allotment is perfectly legal.
Who challenged it?
In a PIL.
Where is that order?
Your Lordships will get, my lord, that Division Bench order at page 2. I filed a memo, my lord, on 18/12/23 with a copy of the judgment. One Samaja Parivartana Samudaya. It's a memo.
What happened to that order?
The Honorable Division Bench, my lord, categorically held that the allotment was valid. That order was challenged before Supreme Court. Honorable Supreme Court, my lord, affirmed it. I have filed that copy also. Your lord.
Memo dated?
It's a memo, my lord, dated 18th December 23.
Page number?
The discussion and the finding on this, my lord, is at page 34. Last
the
5
finding
lines.
recorded.
Yes, finding of the Honorable Division Bench. Similarly, the contention that KDB had no authority to execute sale deed in favor of Joy Ice Creams is misconceived, as the same is contrary to rules. Similarly, the contention that order of grant was made in favor of Joy Ice Creams for an unauthorized purpose is misconceived. There is no material on record.
1 minute, hold on. Yes, Mr. What I got?
Charge against the applicant says, ma'am, that, my lords, they have not made suitable recommendation to the High Power Committee, BDA, my lord, at the time of, my lords.
You heard him all this. So what is your answer for that? Matter has come to this court. Prima facie even sans that we are asking you one fundamental question. Not as an advocate for the Lokayukt or otherwise. See, once this sale deed takes place, what further right of that authority remains? Will not the title divest
From the KIT.
Section 10 TP Act? Then? Please tell us that, you see, what is the logic in a person who does not have the title of a property, a title over the property, and that's a government advocate, that's a government institution, instrumentality of state under Article 12. It sells the property to X. So how can they even have any power to give?
At the time of issuing the plan sanction, my lords, for residential activity, my lords, they had to take.
So who have to give the, see, if that is the argument, then it is an ODP and CDP, the institution which prepares ODP and CDP is the authority. Based on your red, green, yellow zones. Is it within the metropolitan area?
Within the residential.
Within the BDA's area, within the BDA's jurisdiction. Then, even if supposing, let's understand that KIDB says that no, there must be a, you must run a huge industry or something like whatever. Supposing in your CDP, it's a residential layout. Is it possible?
No.
Not possible. Then?
Your lordship, kindly, I will just briefly state few facts.
Yes. Please do that. That is why that we are calling upon you to say.
And measure is was originally a Gomal land. Gomal land. But so this land.
Oh, please make the benchmark must be BDA allotment. Sorry, allotment from KIDB.
But thereafter.
So KIDB allotted. From that stage you can start because the acquisition becomes final. Once the property vests with the KIDB, you can't go behind that.
Government allots it to KIDB on certain terms and conditions.
Correct.
There are three conditions on which the allotment was made in favor of the KIDP. my lord.
Who is aggrieved now? Who is aggrieved now about it?
But, there was it was a suo motu inquiry, my lords, which was initiated based on a paper publication, not a paper, newspaper report. My lords, holding that, my lords, these were Goma lands, and my lords, the allotment, my lords, was made, my lords, contrary to certain conditions that were imposed at the time of allotment.
Fair enough. In the light of these records before you, what do you say?
Say, my lord, that the applicants were only had to recommend only for lords to bring to the notice of the High Power Committee, my lords, that an NOC was required.
Have you initiated any action against the members of the board? Then
That was
who has to give accord sanction?
the High Power Committee.
So you allowed them to who? What is the ranking of those officers?
One was the BDA officer.
Super time scale IAS officer. So whom have you caught? Whom against whom have you issued the notice? Yes, one is the commissioner, one is the chairman of the BWSSB, again IAS, then commissioner of BBMP, again IAS,
Member, Uribreast.
two other members. So what is the ranking of this this person?
Director,
Joint Director.
Town Planning.
Town Planning.
Planning officer.
So please tell us that as per his roster, rather his duties. See that the duties are assigned to a particular officer or official. Please show from your rule book that this he ought to have done, he has not done. Yes, that's what the learned senior also said. Last time we had stopped. It comes back to the same. Our thinking will be common. So we ask the same question. Please show us that he ought to have done this job. He has not done this job. No. Barka. Oh yes. My lord is showing you. Please see page 36. Okay.
Para 4. ADB NOC ಬಂದಿಲ್ಲ ಅನ್ನೋದು ಆಫೀಸ್ ನೋಟ್ ಅಲ್ಲಿ ಹಾಕಿದಾರಲ್ಲ ಬೋರ್ಡ್ ಮುಂದೆ. It is brought to the notice of the board before taking decision.
This writ petition, how many? One or two?
There are two officers.
All right. This writ petition is filed by two officers working as. You are working as, both of them are working as what? As additional director.
Yes.
And joint director in
joint director.
The officers from the town planning.
No, both of you are working in BDA, is it?
Yes, my lord, yes. Both of us are, first petitioner, my lord, was additional director in BDA, and second petitioner was joint director in BDA, and the first petitioner has since retired, second petitioner is still in service.
All right. This writ petition is filed by the additional director, retired additional director of BDA and joint director, additional director town and country planning and joint director at town and country planning, working with the BDA Bengaluru with following prayers. Sri, the list of date is answered. Where is that? Sri Naganand Lavan, senior advocate, submitted that KIDB had allotted a land measuring or number of
7 acres, 16 cents. In the list of dates, item 5, 7 acres, 16 guntas.
7 acres, 16 guntas of land bearing survey number or something.
Survey numbers, my lord, are 42.
42. 154.
154.
157.
157.
160.
160.
Please.
of which village?
Pattandur Agrahara
Of
village.
Pattandur Agrahara village, Bengaluru. Mrs. Joy Ice Creams. Full stop. On 21/7/2006, the land was allotted. A sale deed was executed. The KIDB executed absolute sale deed in favor of Joy Ice Cream on
21/7/2006.
sale deed, all right.
Okay,
On 21/7/2006. Full stop. Thereafter, a private entity. Thereafter, the property was sought to be sold to a private entity, is it?
No, there was a joint
What was the-
development. There was a
All right.
joint development.
Joy Ice Cream entered into a joint development with a private entity. Sold or he's saying joint development?
Initially it was joint development, then my lord sale.
30th of August 2006, it was sold.
Where do we get that? 2006, 30th of August.
My lord, at page 38, 2006 is correct, my lord. Sorry, there is a sale deed in favor of the third party.
Yes, the Joy Esteem sold the property to a private entity on 30/8/2006. Full stop. An application was made by the purchaser to the
BDA.
Secretary
For industrial to residential conversion.
for converting for
Change of land use.
For change of land use. The town planning department of the BDA informed sold to private entity and sold to Prestige Estates. Prestige Estates made an application, submitted an application to the BDA for change of land use. The BDA informed that called upon the Prestige to obtain a no objection certificate from KIDB. Consider the same, to consider the application. Prestige submitted a request to the KIDB
Joy-
to Joy gave it, is it? You
Joy Ice
showed
Cream
some paper.
had submitted. Joy
All right.
Ice Cream meanwhile
All
submitted.
right, Joy Ice Cream submitted an application to the KIDB to issue an NOC. With a letter dated 5/6, with a communication dated 5/6/2008 into bracket annexure A6. The Chief Executive Officer and the Executive Member of the KIDB informed that KIDB had already issued the sale deeds and Joy Ice Cream could approach the BDA for matters pertaining to change in land use and allied matters. Full stop. The BDA finally accorded its approval for change of land use. Full stop. Based on a newspaper report in Prajavani, the Lokayukta initiated CO motu proceedings on 31/12/2010 by issuing a notice to the petitioners, calling upon them to show cause as to why action should not be taken against them for dereliction of duty. Petitioners submitted their reply. The additional registrar of the Lokayukta forwarded the copy of the order
Comments of the
order passed, copy of the ಅದೇನ್ report ಅದೇನದು?
The report, my lord, you could go, my lord, to item 21, page 86. That is the report initiating a disciplinary proceeding. Page 86.
All right. That's very good.
This is what was challenged.
ಅದನ್ನ ಕೊಟ್ರ ನಿಮ್ಗೆ?
Report under section 12(3) was given.
ಮೊದಲು ಅದೇನೋ ಕೊಟ್ಟಿದ್ದಾರೆ. Item 18 is first. Item 18 ಅಲ್ಲಿ additional registrar gave that Lokayukta forwarded copy of the Lokayukta order. What is that order?
Investigation was conducted.
What are initiating?
Committee. That is at annexure, page 68.
Page 68. No, you gave some on 6/4/2013. You gave some notice to them.
Only for their objections.
All right. After Lokayukta initiated the CO motu proceedings, full stop, after holding a preliminary inquiry, a notice was issued to the petitioners. Petitioners submitted their reply and explanation. The Lokayukta
report
recommended initiating disciplinary inquiry as per Annexure A16. Full stop. Para. Shri Naganan submitted that the land in question has been sold by KIDB to Messrs. Joy. It was initially allotted to Messrs. Joy ice cream and subsequently sold to them under a sale deed. Subsequently, thereafter, Joy ice cream has sold it to Prestige. The land has been, the BDA has accorded its approval for change of land use.
Lord, may I interrupt for 1 minute, Lord? One
Yes.
more, Lordships may have to kindly notice, after the report of the Lokayukta, the government issued an order as per A17, page 90.
Saying what?
Initiating disciplinary action.
All right.
14A.
That's right. That
Note ಮಾಡ್ಕೊಂಡಿದೆ.
ಏನಾಯ್ತು? That change of land use is, the approval for change of land use is accorded by a high power committee. As such, the petitioners have, petitioners had pointed out the requirement of an NOC
Annexure A7.
as is found in the agenda at serial number 4 in the notice dated 19/7/2008 into bracket Annexure A7. Full stop. Notwithstanding the mention with regard to, there being a mention with regard to the requirement of an NOC from the KIDB, the High Power Committee has accorded approval for change of land use. The petitioners are low rank officers, and the High Power Committee consists of the chairman of the commissioner BDA, the chairman BWSFB, and
chairman,
the
commissioner. ನಾಲ್ಕು IAS.
Correct.
Chairman. Commissioner.
And BBMP and chairman and commissioner BBMP, who are all senior IAS officers. In addition, the member of town planning and secretary and secretary of the BDA. Full stop. Shri Nagaran further submitted that the allotment of the allotment of land to the Joy Ice Cream was also subject matter of a public interest litigation in which stood concluded in WA number. It is a writ appeal number, is it?
How the first writ petition dismissed ಆಯ್ತು.
PIL ಅಂದ್ರೆ DB ಬರ್ಬೇಕಲ್ವಾ?
ಅದು ಆವಾಗ ಹಳೆದಿರಲ್ಲಿ ಹೇಗಿತ್ತೋ ಗೊತ್ತಿಲ್ಲ, ಬಿಕಾಸ್
All right, in a subject matter of writ appeal number 6845/2017 and connected cases decided on 29/7/2022 into brackets State of Karnataka versus Prestige Estate and others. Submitted that public interest litigation filed by Samaja Parivartana Samudaya was also heard along with said writ appeal. Adverting to paragraph number 22 of the said order, he submitted that this court has recorded that the sale deed has been executed, the absolute sale deed has been executed by the ಅಲ್ಲ ಅದೆಲ್ಲೋ irregularity ಇಲ್ಲ ಅಂತ ಎಲ್ಲೋ ತೋರಿಸಿದ್ರಲ್ಲ ನೀವು ಅದು.
At page 34, Manoj, bottom of 34, last 4 lines.
Submitted that the contention that KIDB had no authority to execute the sale deed in favor of Joy Ice Cream has been repelled. Into bracket para 28. So, in sum and substance, Sri Nagaland submitted that the initiation of suo proceedings by the Lokayukta against the petitioners is wholly unsustainable in law. Para.
The division bench is affirmed by the Supreme Court also, Manoj.
The order in writ appeal number 6845/2017 has been affirmed in SLP number
SLP diary number 36498 of
2022
on 14/12/22.
The Ashwin Halati learned advocate for the in reply. Sri Ashwin Halati learned advocate for the Lokayukta submitted that the land was admittedly allotted by the BDA, was initially allotted by the KIDB. Therefore, KIDB's no objection was necessary. Petitioners were working at the material point of time as the town planning officers, and it was their duty to bring that aspect to the notice of the board and the high power committee. Therefore, the action initiated against them is just and appropriate. We are carefully peruse. I will continue to peruse the records. Full stop. Undisputed facts of the case are that the land has been sold by KIDB to Joy Ice Cream. The KIDB to a request made by Joy Ice Cream to the KIDB. As per Annexure A6, KIDB has informed that since land has been has informed thus and amount, page 34. Full stop. The above communication shows that KIDB has raised no objection, but informed the Joy Ice Cream to approve BDA for matters pertaining change of land use and allied matters. The board note dated 19/7/2008 into bracket annexure A7 contains the subject number 4 in the board note dated 19/7/2008 into bracket annexures A7 records that NOC is required from the KIDB. the resolution has been passed on the very same board note in a meeting held on 28 2008. Before it says 28. There is.
Subject agenda.
Andre, it was
Agenda.
all right.
Agenda note.
Andre, agenda board note, but in the agenda note, in the agenda note dated 19/7/2008.
And they also in para 6 of that same agenda note, they take note of this also, my lord.
Para 6.
Four.
ಅದು 6 ಅಲ್ಲ.
4 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, then 6 ಅಲ್ಲಿ ತಾವು ದಯವಿಟ್ಟು ನೋಡಿದ್ರೆ ಸಮಿತಿ ಸಭೆ ತೀರ್ಮಾನ. Yes.
6 ಅಂತ ಇಲ್ವೇ ಇಲ್ಲ, ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ?
It should be in the, I think there's some page mistake. Kindly go to page 35, my lord. I think ಅದು ಹಿಂದೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಒಂದು ಪೇಜ್. 36 ಅಲ್ಲಿ stops at. Yes.
All right, correct. And at paragraph number 6. So, the change of land use has been accorded by the high power committee, which consisted of Commissioner BDA,
President to Commissioner, Chairman, no, all are IAS officers.
all right, Chairman and the.
It's the board of BDM, it's not a separate committee, it is a board of BDM.
All right, by the ಎಲ್ಲಿ ಸಿಗುತ್ತೆ ಅದು ಬೋರ್ಡ್ ಅಂತ?
ಪ್ರಾಧಿಕಾರದ ಸಮಿತಿ ಸಭೆ ಅನ್ನುತ್ತೆ. At page 36.
Correct. By the board of the BDA. Full stop. In the public interest litigation connected with the writ appeal.
Though it was styled, it was filed by the Samudaya Parivartana. They didn't style it as a PIL. They called it as a local body.
All right. This court has recorded this, para 28. Full stop. In substance, this court has held that this court has repelled the as rightly contended by Sri Naganand. This court has repelled the contention urged by the contention that the KIDB had no authority to execute the sale deed in favor of Joy Ice Cream as misconceived and contrary to rules. Misconceived, full stop. This order has admittedly the proceedings have been initiated based on a newspaper report. Full stop. No action has been taken against the three senior IAS officers who are members of the board, nor against other members. The board note, the subject number 4 and 6 clearly mentioned that a NOC was required. Full stop. Notwithstanding the same, the board has, in its wisdom, has accorded the sanction, which is not accorded the change of land use, which is not the subject matter of this writ petition. Full stop. In the above recorded facts and circumstances of the case, in our considered view, initiation of proceedings against the petitioners is nothing but witch hunting. Full stop. Hence unsustainable. All proceedings squashed.
Next year, A17 and 18, my lord, will have to be.
ಆಯ್ತಲ್ಲ ಸರ್, all proceedings squashed, ಅದನ್ನೆಲ್ಲ ಬರ್ಕೋತಾರೆ.
Grateful, grateful.
Yeah, next. What is?
ಒಂದು 10 ನಿಮಿಷ ಮುಂದಕ್ಕೆ
survey of the matter, my lord, in accordance with the Land Revenue Act, by giving due notice to the Learned appellant. And
To do what?
But, there are the entire, this land is situated in a village, my lord. There are a lot of survey lines.
No, what is the purpose of doing that?
My lord, to determine, my lord, what is the exact land which we have, my lord, used.
So defeat his right again. To defeat his right.
It is a.
You want to start again de novo.
My lord is, we saying 15 guntas, he saying 19 guntas, my lord. Want to do, the survey was done, the.
First you settle for 15 guntas, then we'll permit. Otherwise we'll restrain you from taking any further action. 1 minute, hold on. You settle 15 guntas, then you do the survey. Or deposit that money with the registrar general. We will not permit you to witch hunt. You just heard the order. Now, you will go back to when was the acquisition? Which year? 2000? 2003. So from 2003 to 2024, that is 21 years, you must be at your doorsteps. Now you will start to survey.
But the land, my lord, what the appeal, my lord.
Keep your commissioner present, mister. We'll stop his salary now. He'll say that I'll survey the land.
Understand.
Who has put this note? Please get that file, get that officer. Commissioner, please get the commissioner at 2:30 along with the file. Commissioner shall be present at 2:30 along with that file. Who has put that note also? And if he has approved it, he had it. First, and by before 4:30, deposit the money with the registrar general. Entire value. 2:30. There must be a limit, Mr. Watson.
I understand.
Harassment, there must be a limit. 15 guntas, admitted 15 guntas. Why did you not pay for 15 guntas? What is the procedure of acquisition of land?
Not being followed.
Utilize matter.
I admit. I understand what my lord.
Keep your commissioner present at 2:30. Yes, next.
Most of the matters have become infructuous.
Yes, sir.
But contempt was filed.
Please tell us, whichever have become infructuous, we'll close.
So I'll make it. The contempt was filed to take action against the unauthorized construction of the Tripaksha area.
Hello, tavu numbers ಹೇಳ್ಬಿಡಿ and close ಮಾಡಿ.
Petitions are my friend. Contempt ಅಲ್ಲಿ virtually complied with, except 1%.
ಅದೇ ಸರ್ ತಾವು ಯಾವ್ದಾವ್ ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಕು.
ಫೈಲ್ಗಳು ಕಡಿಮೆ ಆಗುತ್ತೆ.
17.
No. We will go by 63. 63.1. 63 infructuous ಇದೆಯಾ ಚಾಲು ಇದೆಯಾ ಇಲ್ಲ?
Depends on the contempt order. Therefore, I'm making.
Then prepare one tabular column, give it to us. How many we can please come on consensus as far as infructuous things.
So far as contempt petition is concerned, it has become infructuous. These matters were all connected with this.
So can we close them?
Yes.
Please tell us.
All matters.
No. 63 is by Mr. Gautam. Who is Gautam? Can we close this? Can we close 60?
Lord, I'm sorry to make this statement, my lord, that we have filed an affidavit here that all buildings are demolished. I'm appearing to the authority, making a very responsible statement, my lord. There are buildings that are standing even as on now. So, my lord, I did not want to appear for a person who's got no respect for law. I filed, my lord, a memo of
Retirement.
not permission, my lord, to retire in the case. My lord may kindly appoint, my lord, the commission today itself, all at my cost, because I'm doing it for a cause, my lord. A statutory authority comes before this court, makes a submission, files an affidavit, yet may not say a building starting today. They issue notices after notices saying you'll demolish it, they will not demolish it, only the notices are being issued. My lords, they kindly got my statement, and my lords, the commission may kindly be appointed. Now, submission is being made that we have complied with, lords, the directions of this court. It may not be true, my lords.
Then contempt will survive.
At most regret I'm making the submission.
Contempt will survive then.
Who are you?
But I'm appearing for
Pseudo.
which is the custodian of the, my lords, the heritage sites.
So what do you want us to do now?
First, I am seeking my lord's permission to retire, but my lord's submission is being made, my lord, that it is not.
Against the client.
not complied with.
Not to make a submission against the client.
Against your own.
Contempt, basically.
Varala,
Because I got.
not proper.
I'm-
Cannot, he is not supposed to
But my loyalty is towards the organization, towards the law
Can go.
of amendments.
professional.
So I will not appear. Across the river Tungabhadra, there were several ganja resorts were there. So writ petitions were filed. Then all those writ petitions, ganja resorts were demolished because of the order of last Mohan Chandra Court, Supreme Court. And the flood also completely demolished. Across the river Tungabhadra, all those ganja centers are not there. What we are concerned with is the Hampi village in front of temple. Unfortunately, that area is classified as residential in the master plan. So my submission is, if that area is considered and kept only as residential purpose without any commercial activity, let the writ petitions filed by management become inspections. But if a resort comes up, then it is the duty of Hava to demolish it. If my friend says there are illegal activities going on, he must demolish it. But as on today, all those resorts are gone. Only in front of Virupaksha temple, I personally verify. There are some activities are going like bone stay and all.
So please, it is beyond 1:30. Please tell us what is to be done.
They confine it to residential activity, but I can.
Contempt prayer is concerned. Contempt prayer.
Attempt and not present.
No, sir, Mr. Datar, kindly tell us what is to be done with these matters.
They undertake that they will confine only to residential activities in that area.
We are only confining to residential activities, my lord, wherein even the advocate.
ತಾವ್ ಯಾರಿಗೆ?
We are appealing for the petitioner.
ತಾವ್ ಯಾರಿಗೆ?
The original writ petition, PI.
PI.
Yes, PI.
All right. ತಾವ್
What can ask permission to retire from the case, my lord?
all right. But doesn't matter. We noted it. ತಾವ್ ಯಾರಿಗೆ? Yes.
Yes.
So you will be satisfied if they say that it is only residential.
Yes, subject to.
And you are saying that it will be only residential.
Only residential.
Subject to Havama.
So who has filed the contempts?
Contempt, he has filed it against.
Yeah, filed. All right.
That's
So according to him, though they demolished, that authority says they have demolished, they have indeed not demolished.
Therefore, there should be a direction to monitor those activities from time to time.
Only Rupa Paraga.
Your archaeology department. Can you find out and tell us? Please find out. You are also archaeologist. Come back at 2:30. Find and in the meanwhile, please ask any of your juniors to case number which be closed, which should be kept alive, so that it will become easy for us. Right.
Submissions made, not only not for citizen of the
Understand. No, Mr. Budi, you are standing at and you are concerned for the.
For last so many.
Yes.
ಅದೇನೋ solution ಕೊಟ್ರು ಇಂತ last time ಹೇಳಿದ್ರಲ್ಲ.
Right. So 64 were ಕರೆದ್ಬಿಡಿ ಇನ್ನೊಂದು ಎರಡು ಮೂರು. ಇನ್ನು ಇದೆಯಲ್ಲ
64.
These two ಇದೆ, format river, these two.
64, what is that?
64, your lordship may remember, this is the matter where a department inquiry and conducted against 3 officials for against one minor punishment of 300 rupees.
Final hearing ಆಗ್ಬೇಕಾ?
Police no.
ಅಲ್ಲ ಎಲ್ಲ
Final hearing
ಆಗಿದೆ ಬಟ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆಗಿ ಫೈನಲಿ ಆಗಿದೆ. ಅಥವಾ ಮೇಕ್ ಒಂದು ರಿಕ್ವೆಸ್ಟ್
ಮಾಡೋಣ.
ಅಲ್ಲ ಮೇ ರಿಕ್ವೆಸ್ಟ್ ಒನ್ ಥಿಂಗ್, ಲೆಟ್ ಇಟ್ ಬಿ ಪೋಸ್ಟೆಡ್ ಬಿಟ್ವೀನ್ other bench, my lord. If it is to be released from Pottered or something like that, it may be listed before the. ಹಾಗಾದ್ರೆ ಇವಾಗ ಅದು ತುಂಬಾ ದಿವಸ ಅಡ್ಜರ್ನ್ ಆಗಿದೆ. That's why.
All right. Released and maybe posted before release from
appropriate bench.
hearing. Maybe posted before appropriate
bench.
Rajesh sir. Yes. Oh, Mr. Ron. Yes, Mr. Ron.
ಕೊಡದೆ ಇಲ್ಲ ಅಂತ ಮೊಂಡಿತನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದನ್ನ ಇದನ್ನ ತಾವು
My lord, I appear, my lords, in this matter.
Is Mr. Nair?
My lord, item number 67, I appear, my lord. This
No,
is
no,
an
66.
arbitration appeal.
No, no,
Oh, I'm
66.
I'm so
66.
sorry. I'm so sorry.
66 on 26th March. ಆಗ್ಬೋದಾ? Even before that, ಎಲ್ಲ week ನಾವು fill ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ next benches. Yes, 66.
67.
Yeah, 67.
Comma.
Comma.
My lords, I appear for the appellant, my lord.
Yes.
My lord, this is an arbitration appeal.
Huh.
My lord, a section
What
34.
is the matter about?
My lord, we filed a section 34 application to challenge the arbitration award.
But
The trial
if it
court
can,
says that
if it can, Ms. Nair, if it can stand over for a while, can we post it in March 2nd week or something?
very well, very well. It will take some time, my lord, so we don't want to.
That's right. That's right. That's right. 12th, whatever. By consent, Mr. Nair or the appearance per company. Yes, sir. Then what is this? RP government? Oh, that's at 2:30.
2:30.
That's at 2:30. No? All right. We'll come back at 2:30. Yes, please.
Without clarification, what position
What officer?
May I have your lordships kindly? The
Yes,
order
yes.
which the lordships are pleased to dictate, I made a mistake, my lord.
Yes.
The application to BDA was for approval of a group housing development plan. my lord. Group housing development plan.
ಅದರಲ್ಲಿ ಗ್ರೂಪ್ ಹೌಸಿಂಗ್ ಡೆವಲಪ್ಮೆಂಟ್ ಪ್ಲಾನ್ ಅಷ್ಟು ಬರ್ಕೊಳ್ಳಿ ಸಾಕು ಗೊತ್ತಾಯ್ತು. ಆಯ್ತು ಮಾಡೋಣ.
Sorry.
ಇನ್ನೂ ಪಾಸ್ ಅವ್ರು ಹಾ ಎಸ್
ಬಿಡಿಯನವರು RF.
ಎಸ್ ಪ್ಲೀಸ್ ಕಮ್. You are the commissioner BDA. What's your good name, sir? N. Jairam. Did he appraise you of your law officer appraised you of why we have called you? So what's your comment on that? So that's a different matter. So did he tell you the purpose for the entire scenario so that it can cut short the time? We need not get into conversation. 2003, his land was taken without acquisition. Today, BDA is accepting 15 guntas. He is claiming 18 guntas. Whatever, that's a different matter. 2024. After 21 years, you want to today survey a land, find out what is happening. So what should a citizen in this country do? Supposing you are the owner of the land, what will you do? That's a different matter, sir. We are asking you because you are sitting on, it's a hot seat. We understand that. You are a cadre officer, IAS officer.
Senior most.
You are the senior most IAS officer. So please tell us, what a poor man whose land is there, what should he do? If you have taken a land and if he cannot do his agriculture also, supposing if he is only an dependent on agriculturist, 1/4 century you will make him run around to your office. His family will be vanished due to hunger. And 15 guntas, what you have, what you agree that all right, survey can be done. Dispute is only with regard to 3 guntas, whether he get, for whatever, 3 guntas, 4 guntas. For the admitted land, why you are not given for 21 years?
Was done in 2021.
Sorry?
Service case was filed. 21%.
So for 21 years, what you could not even.
So the RFA, in the RFA lot, the adjacent land was being.
No, sir, leave about RFA. What we are asking is, we want you to change we request the commissioner to change your horizon thinking about the litigation. It is very easy to write for orders. You see, in an we are sure that with such a practice, even you will have a very good office with an air conditioner. They are provided from the date that they are in Missouri. We are also given the moment we are appointed here. But what will his client do? It's very easy for us to write something. All right, get a survey done, file an appeal, file a review. After the review, go to Supreme Court. Very easy. Sir, we don't know from what background you come from. We all come from agricultural background.
Agriculture, he is also from agriculture.
You are an IAS officer, will tell you what the problems are. First, name in ROR will be changed suddenly at the instance of somebody. He will not restore it. Assistant Commissioner 136, he will not be sitting in the chair for years and years. Their clerks will write the orders at somebody's instance. Deputy Commissioner will not interfere. We don't interfere. We drive them to civil court. It takes 30 years. These are practical problems. So how will you solve his problem? We are not into a dialogue on this because we are really pained because of what the citizen waiting for 21 years, not even getting 1 paisa, you have taken his land. No, you will first deposit the entire money. Otherwise we'll take very harsh, we'll pass very harsh orders. And you must now see, if you are the commissioner, not that we are finding fault with anybody, we are only requesting. You must pull up your office. You know what the practical situation is? We would request you to do one thing, where you go in disguise to your office at about 11 o'clock, 12 o'clock, 3 o'clock. See how your office is reeking. People are not allowed inside. There are hundreds of agents who claim to get the work done. People are shooed away. On Legal Services Authority, what we get the letters, very painful letters, 70 years, 80 years old people. So what is that? You must have an action plan. That is for your larger. And we have gone vocal, at least speaking for myself from the bench, that it's time that by an ordinance BDA must be closed. You must file an affidavit telling him that on this date I will deliver and you must deliver it. We are requesting you in a request tone, but it is a command. Tomorrow the affidavit shall be here on the table. Clear? Yes. And for balance, whatever that survey giveaway you are doing, ask your officer to go find out how much is the disputed, whatever, sit with him and close the matter and give him his compensation and be done with that.
They have made arithmetical mistake only. It is available.
Sir, we have requested. We have equally inconvenient questions for you. These officers, Papa, they are posted once in 2 years or 1.5 years. They will have about 1-2 lakhs files.
Plain reading of that.
That's right, sir. But they don't reach them. It will be that is why we are requested. We also understand their difficulty. But the point is, we are more pained because your clients are suffer. That is why we are trying to balance it. You understand? ಅವ್ರಿಗೆ ಇಂಡಿವಿಜುವಲ್ ಆಗಿ ಕೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ ಅವ್ರು ಪಾಪ ಕೊನೆಗೆ ಹೇಳ್ತಾರೆ ಸರ್ ನನ್ನ ಹತ್ರ ಏನಿಲ್ಲ ಥ್ಯಾಂಕ್ ಯು ನೀವು ಏನ್ ಬೇಕಾದ್ರು ನಾವೇನ್ ಮಾಡ್ಬೋದು ಹೇಳಿ ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ಮಾಡ್ಬೋದು ಏನ್ ಪ್ರಯೋಜನ that this officer is not personally responsible. It's a system failure. That is why we can only request and ask them to do it. Please see that it is done. Thank you very much. Sorry to have called you. We wanted you to please know that you are sitting on a chair which is very sensitive. It's a hot seat. People must get some relief. And please tone up, if it is possible, tone up on khata issues. People who don't get, see, it is 6th attempt, 7th attempt, people don't get. Once they get, there are series of problems. If you can apply your mind and do something, you will really earn the best wishes of so many people. And goodwill and best wishes of so many people. That's all that we can say. But this problem, we are telling you tomorrow, please send the affidavit to the advocate. Thank you. Sorry. All right, day after. No problem. Sir, we are not putting anybody under tension. We are only asking that please solve the problem. Sit comfortably, write your draft properly, and execute it. That's all. You want day after tomorrow, we'll give you day after. No problem. Day after. All. Thanks.
ವಾಮದಲ್ಲಿ ಕ್ಲೋಸ್ ಆಗಕ್ಕೆ ಲೀಸ್ಟ್ ಕೊಡಬೇಕಾಗಿತ್ತು.
Yes.
ಆತರ.
See, what Mr. Budihal is also, he is a respected advocate of this court. He is, maybe we understand like in the submission what he made, maybe that he's pained at the affairs, what is happening. That is why he doesn't want to represent them, this, that, etc. So,
let me make one submission. For 2 years, Mr. Budihal made a statement. What happened is this: that all the petitioners are Swamijis of various mutts in around the city of Hampi. I personally visited along with my family and took the photograph of these very horrible resorts. Then I submitted to before this honorable court. This honorable court came down heavily, and all those resorts were demolished. Then some of the archaks and purohits, they want to perform this upakarma or something like that in front of this village is there in front of Virupaksha temple. So there, that area, fortunately or unfortunately, is classified as residential zone in the master plan. Therefore, they have a right to carry on only residential activities without any commercial activity like bookshops, and they're all closed now. Now, Mr. Budihal said, he cannot insinuate that even the God cannot question my integrity or the petitioner's integrity. That, let me make it very clear. I asked him, for 2 years, he said, sir, some other unauthorized actions are going on, please take care of it. I said, please give me the survey number and the photograph. I will implead all those persons. and take action. In the meanwhile, what happened? There is one gentleman called Ugrappa. He made an allegation of corruption against Mr. Budyal, saying that he wants to close down the homestays at the behest of the hotel owner. I said, file an affidavit. We will drag him to the last breath before this court. He doesn't do it. He doesn't give a survey number. He doesn't give a photograph. Whoever is forcing him to retire, they must be hauled up for contempt. If he is really interested to proceed with the matter, let him proceed. Why should he retire from the case now? He cannot throw back at the petitioners and run away. My submission is, in front of Virupaksha temple, there is a small village, about 120, where they are carrying on the Upakarma and all that. Let them do it so long as that area falls within the residential zone. So far as the area, Virupaksha Gudde and all that, where across the river Tungabhadra, those ganja centers were there, they are completely removed because of the judgment of the Supreme Court and also because of the flood and calamity. What my Viresh says is, there is a resort coming there, resort. I said, please give, Mr. Viresh, please give the documents or survey number. He doesn't give. Even now I asked him, he doesn't give. Well, why should he run away from the case? If he has material,
We heard it.
somebody makes an allegation against the learned counsel when the matter is pending of corruption, let him file an affidavit. This is not the way to deal with the matter.
All right, Mr. Vasaraj, now have you prepared your list? We will consider all submissions and pass an appropriate.
I may only submit because in our.
Only one last submission, all these people, all these the village people, they come and sit in front of Swamijis and they say, no, you ruined our lives. Why, what have we done? And the Swamijis are fed up and they said, so far as residential areas concerned, let them do it. So those other resorts are concerned, how we will take care. Therefore, I am fed up with this matter and let it be closed. And that is why I made the submission.
Right.
For their consent, Upakarma or whatever it is, let them do it.
Kelly, Mr.
In 3.2, 3.10, all these matters we have already given. The prayer column contains the orders which were issued. On the orders have been issued on the basis of the order which was passed in the Swamiji's case. That was pertaining to.
Which is that case?
This is arising of that is 29848 of 2009.
Is it there in the board today?
But yes, 126 of first matter.
Contempt.
That contempt.
Certified copy tagditಕೊಳ್ಳಿ.
It was passed, my lord. Now there, however, it shall be duty of the authority to locate unauthorized illegal activities in the Hampi World Heritage Area and remove them as quickly as possible, my lord. Now this was the order passed. On the basis of that, they issued notices, they heard us, and they have passed orders of demolition of our residences. So that we have challenged it. And now in view of these compliances which have been made, which already they have filed affidavits. So this particular, and because as my learned friend also said, that
Sir, which is your petition? We are not understanding anything. Which is your petition? Please tell us your.
Second one, 63.194. 60.2.
111194. What is the prayer?
Prayer, I'll show you. And this is prayer.
Who is Mr. A.R. Gautam CCC? Basavaraj is Gautam. Tao Gautam. All right. So this Nema Gowda. You are also with Mr. Datta?
No, he is different.
What is your case? What is the prayer, sir? Yours is a resort or yours is a house? Ad Madaka. Basavaraj, he has come out with a ಅದಕ್ಕೆ ಪರ್ಮಿಷನ್ ಏನು ಇರಲ್ಲ ಮೇಡಮ್. ಪರ್ಮಿಷನ್ ಇದ್ರೆ ಇಟ್ಕೊಳ್ಳಿ ಮಾಡಿ. Without permission ಇದ್ರೆ ಮಾಡಕ್ಕಾಗಲ್ಲ.
One submission. The small village in front of Hampi village, Hampi Virupaksha temple, that area, that writ petitions can be disposed of. All other writ petitions can be kept alive because they are concerned with the illegality outside the.
ಆಯ್ತು, ಅಂದ್ರೆ ಯಾರ್ದು ಯೂಸ್ ಮಾಡ್ಬೇಕು.
Athar writ petition, where the object
60
from 63.2 to 63.10. In all these cases, an order would have been passed for demolition pursuant to these contempt proceedings and challenge.
All right. ಇಷ್ಟನ್ನ ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದಾ?
These houses where these religious activities are going on, they are situated, I think, in front of Virupaksha temple.
100 meters away.
And that area is classified as, that area is classified as
100 meters from?
Virupaksha
Temple.
This is ASI has given it. I'm quoting ASI report.
Can I take your lordship to
May I make one submission, my lord, in respect of 63.11?
Humpy village? It is called Humpy village, no?
Yes, who's this?
My lord, I appear for the respond number 3 from 63.11 to 63.24, which are matters which were filed in the Dharwad bench. In fact, I have filed a memo for disposal because they have an alternative remedy also, my lord. They are challenging the.
You are appearing for which authority?
Havama authority.
Havama. What is your good name?
Prashant F. Gowda, my lord.
Prashant.
Yes, my lord. These 15 matters were filed in the Dharwad bench.
63.11 to?
63.24, my lord.
24. All right. We'll consider your request. Just hold on.
Please.
The Honorable Court's microphone is muted.
Yes, who's this?
Euro, Havamal panel online.
All right.
Gowda.
I'm appearing in serial number 63.5. Sorry, my lord.
For whom?
Okay.
You are appearing for whom?
For the petitioner in serial number 63.5.
63.5.
Yes.
All right. Arises out of WP number source. In the said writ petition, what is the direction?
That direction pertains to Virupapur Gende, not for Hampi village.
Allah, correct. This arises out of this.
Unauthorized. Just in Virupa-
Allah, Delhi, their direction can't tell.
That, you will also get at page number 15 of my contempt papers.
196. Our get.
All right.
Contempt,
Wherein this court has.
page 15 of my contempt papers.
All right. Wherein this court has
It is paragraph 6.
held that it shall be the duty of the authority to locate the unauthorized illegal activities in the Hampi World Heritage Area and to remove them as quickly as possible. Full stop.
Unauthorized occupation, Virupapur Gende.
Like, this is complied with.
That's all right, but put the order.
Paragraph.
Whilst the contempt petition was pending, the writ petitioners have filed this writ petition, the instant writ petition.
Petitions.
Petition one day. Petitions. Petitions. With a prayer inter alia to quash the orders directing them to demolish their properties. But we have heard these matters on several dates. The learned Advocate General, learned Amicus Curiae, learned advocates for the petitioners, learned advocate for the Havama and central government, archaeological department, had visited the Hampi Virupaksha temple and surrounding areas in order to appraise themselves of the fact situation. Full stop. Next paragraph. Today, Sri Basavaraj Leonard, senior advocate, submitted that the contempt petition and the writ petitions mentioned above will be closed with certain directions. He submitted that the first 100 meters from Virupaksha temple is a prohibited area, and the next 200 meters, namely in all next 200 meters, is a regulated area. The buildings in which belonging to the petitioners in the writ petition, in the above writ petitions, fall within the yellow zone.
In the master plan.
In the master plan. In the said zone, pure residential activity is permitted. As per nobody now, please be attentive. Idರಲ್ಲಿ now being spoken to, ಅದು ಏನು ಮಾಡಲ್ಲ. Today what we are filing is this.
Some commercial activities and also.
That is like internet company skills.
ಅಲ್ಲಲ್ಲ ಅದರಲ್ಲಿ ಅದಕ್ಕೆ ಏನಾದ್ರು ರೆಗ್ಯುಲೇಷನ್ ಇದೆಯಾ?
Permitted
as per residential and other incidental activities as mentioned in the ಅದಕ್ಕೆ ಏನು ಹೇಳ್ತಾರೆ?
Zoning regulation. Zoning.
Master plan 2021.
Permitted in zonal
As
regulation.
permitted in master plan 2021 issued by by the Hampi local planning area of prepared by HWH AMA Havama, ಅದೇನೋ correct ಆಗಿ ನೋಡಿ ಹಾಕೊಳ್ಳಿ.
ಎಕ್ಸ್ಪೆನ್ಷನ್ ಮಾಡ್ಬೋದು.
Havama. ಆಯ್ತು.
ಆಯ್ತು.
He submitted that the petitioners have been living in the vicinity in the Hampi village for generations, and in the occupation of ಏನ್ ಮಾಡ್ತಾರೆ? Archaks.
Traditional occupation.
And are in traditional occupation of archaks.
And certain other persons doing some bookshop and bookshops.
And have a bookshop
Certain other trade amenities.
and other activities. Full stop. He further submitted that subject to appropriate directions to the Havama and Archaeological Department to monitor the strict adherence, petitioner's strict adherence to the Master Plan 2021. These petitions can be, the contempt petition and the connected writ petitions can be disposed of. Sri Ashok Harnalli for the petitioners submitted that petitioners shall undertake to follow the Master Plan 2021 in its letter and spirit. They shall not violate the, they have no objection for the Havama and the ASI to monitor the same from time to time.
For running homes, last time you are not there. In certain limited condition, homestay can be for at least one room and a kitchen should be used. One or two rooms, like roomness and one kitchen. For upper karma and other activities. They come and.
ಅಲ್ಲ, ಅವ್ರು ನಿಮ್ ಗೆಸ್ಟ್ ತರ ಇಟ್ಕೋಬಹುದು ನೀವು. ನೀವು ಬೋರ್ಡ್ ಹಾಕಿ ನಾವು ಇದ್ ಮಾಡ್ತೀವಿ ಅಂತಲ್ಲ, ನಿಮ್ ಮನೇಲಿ ಇರ್ಬೋದು.
They will stay only for a day, I think.
ಅದೇ ನಿಮ್ ಮನೇಲಿ ಇರ್ಬೋದು ಅವ್ರು. ಅದು that will be a home that we can't put it in.
Residential thing.
ಆಯ್ತು, submitted, full stop. He further submitted that some of the archaks and purohits perform obsequies, and in order to perform the obsequies, their ಅವ್ರಿಗೆ ಏನ್ ಹೇಳ್ತಾರೆ, ಕ್ಲೈಂಟ್ಸ್ ಅಲ್ಲ, their in order to perform the obsequies, the devotees request, they request, they desire to stay with the archaks. Full stop. He prayed that the stay of such guests in their respective houses may not be construed as a commercial activity. Stop. Next, Sri Basavaraj submitted that such guests will be treated as part of the guests in the house in their respective homes, and it should not be a commercial activity. Sri Budihal Learned Advocate for Havama. Sri Budihal Learned Advocate submitted that as per his instruction, as per his understanding, Havama has not demolished the objectionable buildings, structures. Therefore, he has sought leave to withdraw from this litigation and prays that he may be permitted to retire. He submitted that as a citizen of this country, he is he submitted that he prayed that as a citizen of this country, he submitted that he had a prayer to make to this court as a citizen of this country to appoint a commissioner to examine the examine and report the strict adherence to Master Plan 2021. Para. Sri Budihal's submission was ನೀವೇನೋ ಹೇಳಿದ್ರಿ ಬಸವರಾಜ್, although I don't take.
But paragraph 4 of the order of this Honorable Court is complied with, that there are no resorts across the river Tungabhadra.
ಅಷ್ಟು ಬಿಟ್ಬಿಡಿ ಅವ್ರು ಇನ್ನೇನು ಬೇಡ. ಶ್ರೀ ಕುಮಾರ್ learned advocate for the ASI, learned standing counsel for the ASI, submitted that ನಿಮ್ದೇನ್ರಿ
200-300 meters we can identify the illegal structures beyond that. Havama has to identify because we don't
the ASI has jurisdiction to regulate up to 300.
Not just to show we have got we are as an order lines for entire area minutes, but as far as identification is concerned, records will be whether
ASI will the ASI's records will be restricted to 300 meters, correct? Restricted to 300 meters. However, ASI is also a nodal agency to oversee the activities in the area. Having heard the learned advocates on several dates and as also today in extenso, we are of the considered view that the petitioners who are traditional Purohits and Archaks must not be uprooted of their domicile stay in Hampi village. Oh, all right. Archaks and others. Petitioners ಅಂತ ಹೇಳಿದ್ವಲ್ಲ, petition ನೀವೇನ್ ಬರ್ದಿರ್ತೀರಾ ಅದೇ petitioners. Petitioners should not be petitioners out of whom if some are eking out their livelihood as
Convenience shop.
As Purohits and Archaks and running convenience shops should not be uprooted from their ancestral homes and should not be deprived of their livelihood. At the same time, we are highly conscious of the fact that Hampi is a World Heritage Center village and it must be protected at all costs. Although we are anguished to note the submission of Sri Budihal, who earlier appeared for the Havama, we are anguished. Although we are anguished to note the submission of Sri Budihal, who earlier appeared for Havama. Havama is a statutory body and is duty bound to enforce the master plan and to ensure that the heritage status is maintained throughout. In the facts and circumstances of this case, we deem it appropriate to dispose of the contempt petition and the writ petitions with the following directions. Number 1, writ petitioners shall follow the Master Plan 2021 and shall not carry out any activity which is not permissible, which is
contravening the
yes, in contravention of the master plan.
That's only intelligence, including the activities provided under the ancient monument.
That's a disputed issue because our buildings are much prior to this amendment.
Suppose we have to apply. ಅಲ್ಲ ಈ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಗಂತೂ ನೀವು ಅಡ್ಯಾರ್ ಹಾಕಿ. Next, the Havama shall be at liberty to oversee, inspect and take appropriate regulate, inspect, regulate and take appropriate action in the event of any violation. Para. The ASI then Kelson.
Suppose we have to demolish and reconstruct, we have to take.
All right. Similarly, ASI also shall be at liberty to oversee and same. Andre ಅದು ಎರಡು ಒಂದೇ ಮಾಡಿ ಹವಾಮೆ and ASI. Para. We trust and hope that Havama shall take note of this, take note of submissions of Sri Budihard and take remedial measures if any required expeditiously.
But that Budihard submission is beyond Hampi village, ಬೇರೆ area, ನಾವು ಸಂಬಂಧಪಟ್ಟ. Budihard submission relates to other areas.
Other areas, correct?
Hampi village ಬೇರೆ.
ಹಂಪಿ ವಿಲೇಜ್ ಬರಲ್ಲ.
In agriculture land, what's there are two constructions.
ಅಲ್ಲ ಇದಕ್ಕಿಲ್ಲಲ್ಲ ಇದಕ್ಕಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಬೇಡ ಆ ಸೆಂಟೆನ್ಸ್ ಬೇಡ.
Subject to two riders.
ಅಂದ್ರೆ ಬೂದಿಯಾಳ ಸಬ್ಮಿಷನ್ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಅದು ಬೇರೆ ಅದಕ್ಕೆ ರಿಸರ್ವ್ ಮಾಡುತ್ತೆ.
Subject to two riders. Number one.
ಅಂದ್ರೆ ಬೂದಿಯಾಳ ಅವ್ರದ್ದು ಮೇಲಿನ ಸಬ್ಮಿಷನ್ ಬಿಟ್ಟ ಇದು ಬೇಡ.
If this is the documents prepared by Havama master plan, tomorrow suppose there is a revision in the master plan and the change of land use is made for preservation, etc. Number one. Second one, there was a proposal by the government to shift this entire Hampi village to a better place. Subject to that.
Those are all new
thing will prospective.
Yes. Certainly.
Any change in prospective will applicable at
petition
that point of time.
Deposit the money before the
CCC and writ petitions number 62.2 to 63.10 stand disposed of. All interlocutory application. All right. Our writ petitions are allowed. Annexure in all writ petitions are allowed. ಅದನ್ನ ನೀವು ನಾ ಬೆಳಿಗ್ಗೆನೆ ಹೇಳಿದ್ವಿ ಒಂದು ಲಿಸ್ಟ್ ಮಾಡಿಕೊಡ್ರಿ. ನೋ ಅಸಿಸ್ಟೆನ್ಸ್.
Annexure A to 16
No sir, sorry, we are running out. We should have raised by now. ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಅದು? ಕೋರ್ಟ್ ಆಫೀಸರ್ 8 ದಿವಸ ಆದ್ಮೇಲೆ ಕೊಡ್ತೀರಾ ನೀವು?
ಈಗ ಕೊಟ್ಬಿಡ್ತೀವಿ.
Sir, you must also have some mercy on judges.
Sorry.
Respect to those or
Allowed by. May I make submission, my lord? My lord, in this. My lord, in respect of court mic is muted.
ನಿಮ್ಗೇನ್ ಬೇಕ್ರಿ?
My lord, in respect of this serial number 63.11 to 63.24.
63.11 to 24.
Yes, my lord.
ಆಯ್ತು. ಹಾಕ್ತಿವಿ ಅದನ್ನ ಒಂದು ಮಾರ್ಚ್ ನಲ್ಲಿ ಬರುತ್ತೆ ಯಾವತ್ತಾರು ಒಂದ್ ದಿವಸ. ಥ್ಯಾಂಕ್ ಯು.
These matters are filed in Dharwad bench, my lord. In fact, those are not maintainable.
ಕನೆಕ್ಟ್ ಆಗಿದೆ ಅಲ್ವಾ, ಅದನ್ನ ಬೇಕಿದ್ರೆ ನೀವು RJ-ಗೆ ಒಂದು ಮೆಮೊ ಕೊಡಿ, ಅದನ್ನ ನೋಡ್ಬಿಟ್ಟು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಸೈಡ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡ್ಕೊಡ್ತೀವಿ. ಥ್ಯಾಂಕ್ ಯು. ಎಸ್ ಹೇಳಿ ಹೇಳಿ.
60.11.
ಹಾ,
Memo for disposal of the writ.
ಇವಾಗ ಇದ್ರಲ್ಲಿ ಬೇಡವಂತೆ. ಇವಾಗ ಅದೇ ಯಾರೋ ಲೋಹಿತಾಶ್ವ ಬಣಕಾರ್, ವಿ ಡೋಂಟ್ ನೋ ವಾಟ್ ಇಟ್ ಇಸ್.
He's here.
Memo for disposal of WT to be filed. Lohit, you're Lohitash. So are you disposal can we do? No. Bitbidi adala aವಾಗ. Yes, next. Huh?
Serial number 60.
Wherever in 60?
Yes.
What do you?
Last may kindly have it first week of March because barring is going on in the forest area.
What is it? Who has filed the RP?
We have filed. State has filed the RP.
What is the RP about?
RP state the mistake, not current error.
All right, March. Learned as prayed for by GA. Yes, ಆಯ್ತಮ್ಮ. End of the list ಕೊಡಿ, list ಆಗಲ್ಲ. Oh, this young lady. Yes, madam.
No,